The present batch of applications pertains to an issue as to whether the officers in the Indian Administrative Service, the reporting authority, reviewing authority, and accepting authority of the officers working in the Indian Forest Service. The present applications basically challenge the government order dated 29th of June 2024, notified by the government of Madhya Pradesh with regard to writing of performance appraisal report of the officers belonging to the IFS. The applicants have grievance with regard to paragraph 2 and 3 of the CG also. We are referred to certain clarifications and office memorandums issued by the Union of India. Clause 4 of the clarification dated 28th of December 1990, which is to emphasize that in assigning reporting authority, due regard must be had to seniority and pay scale of the reporting officer vis-a-vis a member of the service reported upon. It notes instances where ACRs were initiated by officers the same batch or pay scale as the officer reported upon, and according to advice of state governments to avoid such assignments. Other states that, as far as administratively feasible, the reviewing authority should be in a higher grade than the reporting authority. We are referred to the judgments given by this court in the case of State of Haryana versus PS Wadhwa and the order dated 22nd of September 2000, passed by this court in this very proceeding in the case of Santosh Bharati versus State of Madhya Pradesh. It is pertinent to note that this court in the order dated 22nd September 2000 had specifically considered the issue with regard to who should be the reporting authority, the reviewing authority, and accepting authority, insofar as officers of IFS are concerned. It is further pertinent to note that the state of Madhya Pradesh had also filed an application seeking modification of the directions given by this court in the said order dated 22nd of September 2000. This court in the said application had called for the report of the CEC, which was accordingly submitted and was accepted by this court. After considering the said report of the CEC, the application filed by the state of Madhya Pradesh was rejected. The legal position as approved by this court, two separate orders of this court, and as rightly understood by the MOF, as could be seen from its letter dated 8th of November 2001, is that insofar as the writing of ACR up to the rank of APCCF is concerned, the reporting authority should be the immediate superior authority in the forest department. The position is clear as regards reviewing authority or reporting authority in relation to officers up to the rank of APCCF. It is clear that except the PCCF, the reporting authority has to be a superior officer from the IFS. It is only with regard to PCCF that the reporting authority would be a person to whom he reports and who is superior to him in rank. No doubt that if necessary, the state government can provide that the collectors and commissioners can record their comments on a separate sheet about the performance of the IFS officers in relation to the implementation of developmental work funded by the district administration. However, the same is again required to be considered by a superior departmental officer of the IFS. Further, consider that the GO dated 20th June 2024 is totally in violation of specific directions issued by this court by its order dated 22nd September 2000 and 19th April 2004. Result of the table annexed at Annex 8, the compilation of the learned amicus would reveal that except the state of Madhya Pradesh, all the other states are scrupulously adhering to the directions issued by this court in the opposite order. There is no hesitation to hold that the impugned GO is rather contemptuous in nature, in as much as the said GO, which is in violation of the opposite orders of this court dated 22nd September 2000 and 19th April 2004, has been issued without even seeking clarification, modification of this court. You could have very well proceeded to initiate contempt proceedings against the officers responsible for issuance of such GO. However, we refrain ourselves from doing so. GO being in violation of the directions of this court is liable to be caught and set aside. The result, the applications are allowed. The impugned GO dated 29th June 2024 is held to be in violation of the orders passed by this court in the present proceedings dated 22nd September 2000, which is reiterated by the subsequent order and is therefore quashed and set aside. State of Madhya Pradesh is directed to reframe the rules by strictly adhering to the directions issued by this court by the order dated 22nd September 2000 in the present proceedings, which have been clarified by the MOF in its letter dated 8th of November 2001 and also clarified by the DOPT by its letter dated 2nd September 2004. The same shall be done within a period of 1 month from the date of this order. We place on record our appreciation for the efforts put in by Shri Information, learned amicus query for extending support and suggestions, and Shri Tushar Mehta, learned Solicitor General, for taking a fair stand on behalf of India Pradesh.
Great.
The Lordship's permission, the press, at scene number 30, there is no possibility.
State mention.
Oh, sir, I'm sorry. Yes.
My lord, this is a matter relating to the judicial officers of Madhya Pradesh, my lord. We are seeking the same relief which is granted to Telangana officers. A very short point. And it was detagged from all India judges for this very reason. And my lord, the matter is being shown from time.
The
Age of superannuation.
That's for every state to decide how can.
No, state is agreeable. Now they say because of the pendency and directions in all India judges on earlier occasion, unless this honorable court gives a clearance, we will not do it. They are ready, my lord. There's no difficulty about that.
Who is appearing?
For the state, my lord, Haman is on record, my lord. Last time he appeared, and his affidavit also, my lord, they, even recently, we made a representation to the High Court. High Court says unless the Honorable Supreme Court clears it, we can't do anything.
They want to make it 61.
Yes. Not 62, 61, although the state officers are 62, because Telangana is granted 61 by this court.
That's it. It can't be 62.
Yes.
There has to be some. Next week.
Let it be listed next week also, my lord. We have no issue.
Okay, next week.
Next week.
Your Lordship, this is related to Sariska Tiger Reserve. Your Lordship has passed the directions on 11th December to constitute a committee and then implement the recommendation 1 to 6 and 15. However, they have implemented recommendation 1 without constituting a committee, and they have banned the entry from all the gates now and without hearing the trust.
They have banned the gate entry.
Entry, yes, without forming the committee, without taking any instruction.
Well, you know what has happened in. No, but Sariska, we have directed them to provide for electronic buses and all that.
Yes, Your Lordship, they have not done anything. They have not.
Give a copy to Mr. Parmeshwar and the Council for the State of Rajasthan.
Yes, Your Lordship. We have served though. We have served them.
There are two matters in 803.
Next week.
It's there in the next week.
This is there.
You give the list of the matters which should be listed.
Hand it over to the court.
Malad, there are two matters in 803. Malad. The first one is mine, Malad, if I may mention. Malad, 125603. No, this is regarding Malad's heavy destruction of forest Malad in Khasi Hills, especially the Riboi district, Malad, where a university campus is coming up and there are several illegal mining.
Malad, all fresh IAs we have put next week.
Malad, if my lords may kindly post it along with the development matters.
All fresh IAs are coming next week.
Next week, Malad, I am grateful.
Malad, that list I have passed on to the court master.
Yes.
We have supplied a copy to the learned amicus, Malad.
We'll have them in the next week. Yes.
Grateful.
Plus, I mean, according to your lordship schedule, we'll have all the fresh matters on Monday itself, so that the first half, all the fresh matters are done. Because then the bigger matters can be taken.
Bigger matters.
Bigger matters.
Which matters you are listing?
Millad's Balco is there, Mathiran is there. Your lordship has listed those two specifically final disposal. Milad, that might take some time. Then Aravalis are there, Milad. That's about 400 IAs are there in the Aravali matters. So those might take some.
400.
400. But the,
Uh, uh, How many have you cleared till now?
that's,
How many have you cleared till now?
that's from October 22, this must be around 800, 900 IAs would have been done by now. 900 matters by.
Next week, yes.
Great.
Oral mentioning only matters which can't wait till one day. If somebody is dying, somebody is being hanged, somebody's house is being demolished. Otherwise, if anybody mentions that matter, will directly dismiss it at this stage of mentioning. Otherwise, all matters will come in the next 2 weeks. And what is this? When the judges are willing to work in the vacation, first 5 judges are sitting in first week. And the blame is on us because of the pendency. It is the lawyers who don't want to work in the vacation.
Some lawyers. Some other lawyers want to work throughout vacation.
For different reasons.
The papers before the changes in payment, they are not being placed for the last 4 months. And we have no choice because this is a referred matter. And there is a judicial order passed saying that please place the papers.
Which matter?
I have this order is passed, judicial order. And we are changing with the registry and they said you file an IA for implementation of the judicial order. Your Lordship may just call for the papers and fix any date we are ready to go.
So first, we'll have to constitute a 3 judges bench because
Any regular bench, my lord, we have no.
no, the order says it says.
Yes, it has to be, it is a reference.
Judicial order, so we are bound by it.
It is referred to a larger bench.
July mein dekh lein.
Well, it's, I fall in that category. Well,
Let us see, if you don't fall in that category, we'll dismiss it right now. Choice is yours. We have made it loud and clear. Otherwise, all those matters will be listed in the next 2 weeks.
No, I'll tell you why. I believe your Lordship has already day before yesterday on this mentioning directed. Day before yesterday on this mentioning, my Lords had directed that since Justice Narasimha is on leave, any bench where Justice Bagchi is sitting should be listed before that. This is what Justice Narasimha had intended. It's a formal orders only. That's all that is to be reminded.
What is the urgency in that? It can
Urgency is that the
we'll direct it to be placed before Justice Narasimha in the vacation.
Justice.
Narasimha, when he comes back, we'll direct it to be placed before in the vacation.
Only one thing, Justice Narasimha himself had said is subject to orders, Honorable Chief Justice. He and Justice Bagchi had for formal orders, a security of 300 crores has to be substituted. ED has agreed. What is happening? The main security is being held up.
So he's sitting in the vacation, we'll direct it to be placed before him.
He's coming on 30th is what I am told, subject to correction. I am told it's 30th of June.
Can wait
For
till
formal orders only of substitution of security. ED is agreeing, Wallace. ED is agreeing.
wait till he comes.
Lords, item 15,
They're verified.
item 15, if I can, Lords.
Vacation में लगा लीजिए उनके सामने.
There's a matter where it's already been listed, the registry has taken it urgently, listed it on Monday. But it's an MA for a recall of Justice Parthiwala's order. Justice Parthiwala is not sitting on Monday. Could it be on Friday?
He's not sitting in.
He's not.
He's not sitting in vacation.
That's the problem. It's for a recall of his order where, as the petitioner had appeared, a detailed civil appeal judgment was passed. Respondents were not called upon, with no notice was issued, caveat was there not
लगा
honored.
लीजिए Friday.
That's the
Your Lordship, I am also in one of the connected MA.
820.
Lords, may I make a request?
Your Lordship, I am also in the connected MA. I am also in the connected MA in the same matter in which Gopal sir had mentioned. That may also be.
Matters which were directed by your Lordship's bench, my Lords, to come up on a particular day, this particular bench,
Obliged.
your Lordships, my Lords, on 20th. Had to go back the matter, my Lords, because it was an,
What is the urgency?
it was, so can I pray for it to be next week, my Lord, not this week, next week? Since your
Next
Lordships
week
are,
we would be taking a green bench matter. So what is the urgency?
it was a criminal appeal where I've been convicted in a reversal. The judgment of the High Court was sort of indecipherable, my Lord. So your Lordships had intentionally kept it after 8 weeks. So it had to go back to Punjab and Haryana. So that was the matter, my Lord. So
January 26th.
My lord, may I request?
Since your
Bill
lordship.
number
is speaking.
30.
January 26th.
Bill number 30 is a big matter. Last week also it could
I
not
told you, don't mention otherwise, it will come in July.
No, since we wanted to work in the holidays, my lord, that's why I was
We
mentioning.
would like to concentrate the next week on environmental matters.
All right, I'll mention it in July.
My lord, Bill number 30 is a bail matter. Last week it could not be taken up. He is 68 years of age. My lord's may have in the next week. Bill number 30.
We are already telling you, you come through the regular mentioning process, everything will be listed in the next 2 weeks.
My lord,
In spite of you want to mention, we'll dismiss all such matters.
We will do that.
permission, may I mention matter? Your lord,
So this matter, 54 persons are already released from their job. The
beg
matter
pardon?
was listed before Justice Narsimha and was directed to be listed on 19th of May. But your lordship may kindly keep it.
Keep it in the vacation before it.
Vacation with your lordship next week because they are already released from their job and the recruitment
Nothing
process.
will likely to happen in 3 weeks.
Your lordship, recruitment process has completed. It is just the matter of the
Let it be listed in vacation before it.
May I mention, my lord, fresh
item 11, your lordship, application is for extension of time to surrender is expiring tomorrow, your lordship. Time to surrender is expiring tomorrow, your lordship.
When did you know that the time is expiring tomorrow?
Your lordship, the appellant is a 70-year-old woman, she is for socialized only for extension of time.
Your lordship, may I mention, your lordship, this is a fresh matter. Before 30th, your lordship, any day. Before 30th is election due, your lordship.
Take an excuse also. We are telling you that all those matters will be listed in the next week. Still,
But my lord, may I mention a fresh SLP, my lord, because this is important because this pertains to the construction of passenger jetty and terminal facilities are right in front of Gateway of India. So if the stay is not granted in that matter, if the matter is not.
did you approach the High Court?
Yes, my lord. In the High Court, the stay was not granted. That is the reason we residents have approached the Honorable Supreme Court now. So this matter may kindly be listed on Friday, my lord.
Next week.
My lord.
Lord, may be permitted to
Deeply
mention the matter, my lord. This pertains to the bench of Justice Samanullah. Lord, we mentioned the matter. I'm seeking recall of an ex parte order by which the order of anticipatory bail, which was granted by the Bombay High Court, has been, Lord, cancelled. Because we were never served, Lord, with the proceedings. Lord, I mentioned the matter in the morning. Lord, we were told to mention before your lordship spoke.
Lord,
Your lordship.
So there is a matter before Justice Padiwala's bench on Friday. That's a suo motu notice relating to some suicides which happened in coaching centers. So there are some petitions pending, my lord, in Delhi, Rajasthan, etc. We filed the transfer. We tagged with the case of Friday.
Lords, may I mention, I want to mention one MA. Item 813 in the list for mentioning, my lords. This matter pertains to auction of a plot, my lords. This auction is tomorrow. This is a leave grant matter.
When was the auction fixed?
Lords, I got to know about this advertisement last.
When was it notified?
Lords, the notification date is not there on the advertisement, my lords, but I got to know
When
last.
was it published in the advertisement?
Lords, it was published on the website, my lords. It's not.
When?
2nd of May, my lords.
What is today's date?
Lords, 21st, my lords. Tomorrow is the auction.
Next week.
Your lordship, I want to mention one MA.
14 July.
In
Your lordship, may I mention the matter at 8181 mentioning list? It's an anticipated bail application.
818?
Yes, mentioning board. Unlisted. It's an application for petition for anticipated bail. High Court has rejected. May I request to be on Friday?
No, next week.
Your lordship, I want to mention one MA.
Petition, so next week I am comfortable.
But next week you don't have to mention it. Just mention it to the register.
I want to mention one MA. This is regarding the demolition happening in the slum area of Mumbai. And it is, the demolition notice has come for the 27th. And the matter is supposed to be listed on Friday, 23rd. But Justice Vikramnath is on leave on that day. So I may request your lordship to list it on with some other bench or.
What has happened before the High Court?
Your lordship, High Court has not provided us with the stay, and partial demolition has already took place, and we have not been given the accommodation as promised by the builder. So the people are on road, your lordship.
So your petition is already dismissed?
No, your lordship, yes, sir.
Yes, your SLP is already dismissed?
Yes, lordship. SLP was dismissed, and in the High Court, we were not given the time to.
Whether the SLP is dismissed?
Your lordship, yes.
Then what is pending?
MA, we have filed one MA.
MA for what?
MA for the stage that the demolition should.
After the dismissal of SLP?
Yes, Lordship.
What is this procedure?
Because we were not being given the notice and we were just demolishing to.
Were you heard by the bench of?
Your Lordship, at that time demolition didn't take place. The demolition took place after that.
You may take on board, reject.
So,
My lord's permission,
Let it come in the regular course.
my lords, may I have permission to mention a matter which my lords yesterday in a mentioning, and somebody else is mentioning in a connected application in arising out of the same civil appeal. My lords had allowed that to be listed on the 23rd. So I'm merely seeking that my application be tagged with that. I'm so grateful, my lords.
May I mention item 815, my lords, it says unlisted mentioning the number has been given. This is an extreme case where she is neck down paralyzed. We are serving lots her pro bono, but the only thing is she needs immediate medical need. She is now losing her voice, her finger sensation is also going. She's neck down paralyzed. Case facts are gross. I don't want to mention what that's.
No, it's a case for what?
Lots, we have filed a writ petition here.
For what?
Lots seeking Article 21 lots intervention of this honorable court. She needs to be provided some medical urgency. She has nobody around her. She's completely. I'm so very grateful.
820, interim protection has been vacated with the High Court on 14th May. I had interim protection, husband and wife in 420 case. All I'm requesting on next week's Malasib.
Next week we have been telling, I don't know why the bar doesn't want to listen what we are saying so many times.
My lords, I am seeking liberty to mention, my lords, my written submissions may be taken on record. We had time till Monday. I have e-filed it on Tuesday. I'm seeking liberty for taking.
Lords, may I mention item 823 in the unlisted mentioning list, my lords. This is a tender matter, my lords. High Court has dismissed on 15th, my lords. It's regarding that Nauchandi fair, my lords, started from 25th, my lords. Otherwise, it will become infructuous, my lords.
Next week.
My lords, 25th is the start date, my lords. It may be tomorrow or.
Your Lordship, I am appearing for the petitioner wife in item 10.
Good.
So here the mediation has failed and I am seeking transfer of. I'm
appearing for the other side.
Please, my lord, I beg to appear for the respondent in this matter.
Yes.
I'm seeking transfer of this matter, section 13 petition from Ranchi to Bhubaneswar. I'm staying in Bhubaneswar and I'm also working in a company in Bhubaneswar. My child is studying.
My lord, the respondent here is a serving wing commander with the Air Force. He is presently posted in an active posting on the Western Front as part of Operation Sindoor. Those are my instructions. And secondly, he has been paying maintenance as accorded to the wife by the Air Force authorities. And secondly, he is willing to pay for all visits, whichever visit the petitioner here may be made to undertake to the family court in Ranchi. He is willing to pay.
So you are posted on the Western Front?
Yes, my lord. Those are my instructions. I don't have the details.
From there you want to come to Ranchi? And not Bhubaneswar?
My lord, it will be convenient for the respondent to handle his litigation in Ranchi, and he's willing to pay for the stay and travel whenever the petitioner here has to travel to Ranchi. He's willing to undertake the expenses.
Allowed people to appear video conference.
My lord, then in that case, the respondent may be allowed to appear through VC whenever he is physical.
Specifically that you don't want
Much
to listen
obliged.
what we are dictating.
Much obliged, much obliged. My apology, my lord. I am obliged. Grateful, my lord.
Rising out of the very same notification, Lordships have issued notice and that is pending. This is recruitment of district judges from the bar. Another candidate had filed a SLP at page 90. The Lordships have issued notice and that is pending.
Notice back.
Grateful.
Page 224 is the judgment of your Lordships, my lord, which has granted relief to the identically situated petitioners. Page 224 is your Lordship's judgment. Unfortunately, your Lordships have affirmed the views of the other high courts. Madras High Court under the impugned judgment says we don't agree with the other high courts. The Lordships will kindly see the order of your Lordship. It is relating to the accounting senior assistant accounts officer and senior accountants, my lord. Revision of pay as per the 5th Pay Commission recommendation. That your lordship will kindly see all the other high courts decided in favor of the.
Returnable 8 weeks.
Sir, that's for delay. Delay may be.
This will be covered by our judgment now.
Just one submission, my lord. 10 months he's been asked to run, been forced to run from pillar to post. Can I request my lord to direct them to comply with that and then?
We have already directed and we have modified yesterday that all areas are to be paid within a period of 3 months.
10 months we've been, this is the only submission. 10 months after.
We have already directed areas to be cleared within 3 months.
Your lordship will direct that this also comply with that and then give a.
It is applicable to all judges in the country on a pan-India basis. As long as you are an Indian citizen, you will be covered by that judgment.
Peculiar.
And I don't think that any person who is not an Indian citizen would be.
Last 10 months, you have not been getting a pie by way of terminal benefit.
Judgment is already covered by.
Comply by, sir.
By our judgment and order dated in Swan.
Your lordship will say comply.
Yeah, already directed.
All right.
How many times we have to tell you?
No.
This is the 4th time that we are telling you that we have directed the areas to be paid within 3 months from yesterday. And it is applicable to all judges in the country. How many times you have to repeat that?
All right, don't have to. Only because of this, I pointed out. If your lordship would give a time for compliance, it would be good. All right, I take it then.
Please, I had a mining contract which was to expire on 30th of June 2023. The government, the state of Madhya Pradesh, we entered into an agreement on and by which we were granted an extension of 2 months on a condition of we pay 10% of the original contract amount. That is 2.75 crores I paid. Now, immediately thereafter, that document your lordship would find at page number 166, by which it was extended by 2 months. So I had to pay 10% of the contract amount. Later, on 7th of July, they issued a general order by which it was extended by 3 months. So what happens, everybody else gets it for free to lift the sand. It's not for excavation, to lift the sand. I am required to pay 2.75 crores. What I go to the High Court and I say that extend that 2 months period because I have already paid 2.75 crores. But High Court says, no, you have been given 3 months period. That's good enough. But please have a look at that page 167. 167. Bottom, if your lordship sees. %10% I have to pay. So they grant an extension of 2 months. Now your lordship may please see the second circular, that's at page 206. This grants blanket extension for 3 months all throughout. And please see page 220. What they do is now.
Tell us what is the error in the.
That's the error. That's the error. The High Court doesn't consider that I have paid 2.75 crores. That has not been looked into by the High Court. That 10% amount I have paid to the contract amount. And therefore, if your lordship sees page 20.
That you have already been granted extension and you have.
But that was.
You are availed of that.
Not what happened is this. If you,
therefore, I was. According to the High Court, it does not apply.
Therefore.
Or this is not a case of cancellation.
It's not a cancellation.
Therefore,
please see
clause which is applicable on which you are relying on.
Therefore, kindly see page 206 for a moment. Page 206. This is a blanket extension for all the mining contractors. Page 206. Page 206, if I'm with your lordship. In reference to the above subject, the SAN group previously contracted in the district whose contract period till 30th of June 2023 and the period of sand storage license approved on under 18(6) of Madhya Pradesh so and so was till 30th June. Due to the sand mining being banned during the rainy season, sand is available from July to September. To ensure supply, the state government has taken the following decision. Now
whether in your case also it was banned?
Yes. So, my lord, I could have got extension otherwise. Now what happens is, please see this.
Where have you said so? That it was banned?
It was banned throughout the state.
Let's see where you have the pleading.
Just show me.
And from the order.
Quickly. Actually, I think at least show that. No, have you mentioned it? Maybe it's central. May I request to have pass it over, I just get the copy of the, but that rule is general. That rule
Thank you, thank you.
Your lordship, pass it over, I'll just.
Thank you.
Lord, may I say in the alternative? Your lordship.
Withdraw this and file a suit.
What happens is this, only I happen to pay 2.75 crore.
You are on a different, totally on a different pedestal.
Miller, only one pedestal is different. I entered into a contract, then may I file a review, Miller? Your lordship may permit me to withdraw, I'll file a review. And point this out, that I paid 2.75 crores.
Allowed to withdraw with liberty to file for. I'll review.
I am so.
Please, my lords, I'm seeking a short passover.
What passover now?
Please, my lords. My lords, this increasing incidence, my lords, of heat stress is today, my lords, affecting almost every citizen. Last year, my lords, more than 700 deaths took place, and I've handed over, my lords. There's a compilation of deaths which I have placed, my lords. Today, my lords, earlier, my lords, the predominance was only in 3 regions. That is the northwestern, my lords, central, my lords, and now, my lords, it has increased to all other, my lords, the east coast, west coast, my lords, the peninsular region, the southern region, the northeast, east, every region is affected, my lords. IMD report says that 70. Please. My lords, there are the NDMA guidelines, there are national guidelines, my lords, because June is round the corner as sweltering heat is predicted. So, my lords, the short.
We have made it dinner with 2 weeks.
Please, my lords. Much obliged.
Page 49.
Yes, lordship, please.
Yes, Mr. Solicitor.
My lord, with my lord's permission,
sorry.
I don't want to disturb your lordship convention. The only thing is, since I have come from state of Jammu and Kashmir,
Thank you.
my lord, I have given a breakup of the concept on the religious lines, my lord, in my application, and that is very important. Your lordship may require my assistance in that. Only why we read one paragraph, my lord, of my application.
Yes, Mr. Solicitor, you may begin.
Which, my lord, may reserve my lord right, my lord. Anytime, my lord, I can assist your lordship on that.
Assist at that stage of final hearing.
Lord, only one minute of.
Sorry.
1 minute of your lordship's valuable.
Sorry.
Lord, we are, Lord, a person, Lord, inside the
Solicitor,
JPC.
you may begin.
Lord, we had been participating in the JPC.
Are dealing with. We can only make a request to your lordship, my lord.
Because this is a very important point, my lord, which was not argued before your lordship.
Concept.
That is why I wanted to place it before your lordship.
My lord, concept of Waqf by user, my lord, on the religious lines, my lord, has not been, my lord, fully, my lord, elaborated.
Don't do this. This is not done. Please, sir, I'm requesting you.
No, please, I'm just addressing to the court.
No,
I need not to take a permission from you.
They have said no yesterday, we will not hear anybody.
I reserve my, your lordship may grant me.
Lord, before the learned.
Sorry, Mr.
Permission only I'm asking.
Sorry.
Lord, this is with regard to the JPC.
Sorry.
If your lordship looks into our affidavit, that is enough, my lord. A rejoinder has made it very clear.
We'll read it.
Joint Parliamentary Committee, my lord, was not
Yesterday
taken
said,
into consideration.
Mr. Wilson, yesterday we have said that we will not hear anybody.
Yes, my lord. My lord, two things.
Yes.
Not only JPC, my lord.
Lord, kindly see.
Early morning, the bill was.
Very difficult to work here.
Obliged, my lord. Obliged.
There is no discipline, no respect for the court. Really difficult court.
Yes. Lord, please. Lord, your lordships have before your lordships, my lord, petitions filed by individuals, mostly, my lord, 99% in a public interest litigation and not by any affected individual. And that would, my lord, make the difference because your lordships are dealing with an enactment which is passed by the legislature whose competence is not in question. It's nobody's case that the parliament did not have the legislative competence to pass this law, because this is one of the factors which is the possible only factor where stay of a statute is granted or something at that threshold that this legislature had no competence to enact the law. Now, my lord, I will just briefly point out to your lordships, my lord, what was the process, a detailed process which was undertaken, my lord, before the Joint Parliamentary Committee. I'll not read anything, but please, my lord, take my note and please come to page 9. I'm sorry, take my affidavit and come to page 9. My counter, my lord. My lord, counter. Lord, this is not a case where the ministry prepares a bill, it comes before the House, voting takes place mechanically, and the bill is passed. My lord, we were eradicating the menace which was noticed as back as in the year 1923, 102 years back. And therefore, my lord, we were very careful that each and every stakeholder is consulted, each and every voice is heard, and thereafter it goes before the parliament and a full-fledged debate takes place. Lord, please have a look at page 9, Lord, at para 21. Lord, this I would request your lordships to bear in mind, because it is my case that few of the petitioners cannot claim to represent the entire Muslim community. We received 97,000 representations. I'm sorry, 97 lakh representations. The Joint Parliamentary Committee had 36 sittings. Please come to page 9, para 21. Apart from the representations received by the Joint Parliamentary Committee, the Ministry of Minority Affairs also received representations. I'm sorry, my lord, my counter. Page 9, para 21.
We have.
I'll be very brief and crisp. Apart from the representations received by the Joint Parliamentary Committee, the Ministry of Minority Affairs also received representations highlighting the need for legislative amendments which include mismanagement of Waqf properties, deliberate encroachment and unlawful transfer of Waqf land, inefficient functioning of Waqf tribunals, sweeping powers to arbitrarily declare property as Waqf as per section 40 of the Act, allegations against Waqf board officials along with general grievances and representation from Ahmadiyya community. This is a schedule, very backward community amongst Muslims. Now, my lord, I'm not reading para 23. These are the state governments who were consulted. They came through their representatives. Then, my lord, page 11, para 24. My lord, 25 Waqf boards were consulted. Consulted means they came, they gave their representations. There were deliberations with the Joint Parliamentary Committee, clause by clause, and Joint Parliamentary Committee records that on this particular clause of bill, A board has this objection, B has this suggestion, C is agreeing, whatever. I'm not giving examples. Now, please see, my lord, page 12. We took inputs in personal meetings. We means the JPC with, my lord, these institutions, my lord, 28. I'm not, my lord, repeating. All India Sunni Jamaat Ulema, Indian Muslim Civil Rights, Uttar Pradesh Sunni Central Waqf Board, etc., etc. Lord, thereafter, Lord, a voluminous report was prepared where some suggestions by the stakeholders were accepted, some suggestions were not accepted, and they have given reasons why suggestions are either accepted or not accepted. When suggestions were made to amend some sections that it is not a part of the bill, please make it a part of the bill. Lord, the committee suggested that it should be made a part of the bill. And that bill was presented before the competent legislature and passed with, Lord, unprecedented debate. Now, your lordships, my lord, kindly come to my lord note. Lord, I have filed a note, my lord. I'll take your lordships one by one. One section after the other, my lord, which were under challenge. My note is confined to 3 issues, but I'll answer all issues, my lord, which were raised. Your lordships have my note. Lord, kindly come to page 4. 3R is quoted, my lord. Section 3, subsection R. Waqf means the permanent dedication by any person of any movable or immovable property. Please pause here for a minute. Lord, 1923 Act said a Muslim can create a waqf because waqf by a very nature is an Islamic concept. 1954 Act again said only a Muslim can create a waqf. 1995 Act also said only a Muslim can create a waqf. Now a very interesting amendment comes, my lord, in 2013, which came to be passed in November 2013. Incidentally, my lord, few months before the country was to go for general elections in March 14, where the inclusion was not Muslim, any person can create a waqf. Bear this in mind, my lord, and I'll come to, my lord, why this was done away with. Now, waqf means the permanent dedication, now amended, green is amended, any person showing or demonstrating that he is practicing Islam for at least 5 years of any movable or immovable property, having ownership of such property, and that there is no contrivance involved in the dedication of such property. Well, 3 things. A, he has to be Muslim. B, he has to be a Muslim practicing Islam for 5 years. And 3, most important, he can create a waqf of the property he owns. He cannot create waqf on somebody else's property. This is to, my lord, eradicate the menace of encroachment of private or government property. Now, please see, my lord, this has a saving clause. I'll come to, my lord, justification on each of them. Please see the last. My lord, one more thing which we have added. My lord, just, my lord, a good thing, positive thing, my lord. Earlier, my lord, there is a concept of Waqf al-Aulad. Waqf al-Aulad means that it's dedication of property to Allah, but for the benefit of my children. The children initially, till this amendment came, did not include daughters, widows, etc. This is introduced for the first time, not under challenge, fortunately. Now, please see, my lord, proviso. Provided that existing waqf by user properties registered on or before the commencement of the Waqf Amendment Act 25 as waqf by user will remain as Wakf properties. My lord, kindly pause here for a minute. This is a prospectively applicable provision. If you have registered yourself as Wakf by user, then it is saved. With two exceptions. Except that the property wholly or in part is in dispute. Lord, kindly pause here for a minute. I have, my lord, clarified in the affidavit that dispute would mean a private party may have a dispute with the property of the Wakf. My lord, I as a private individual, a citizen, may have filed a suit that this is my property which somebody has declared as a Wakf. That would be governed by the judicial adjudication, what the court will ultimately adjudicate upon. Lord, I don't think there can be any objection to this. If there is a dispute between private parties and a Wakf with regard to the Wakf property, it would not be a Wakf because it would be governed by the adjudication of the competent court. Second, is in dispute or is a government property. Lord, kindly appreciate, my lords. Wakf, we are dealing with Wakf by user. Lord, first category of Wakf is I have a property, I dedicate it to the Allah for a particular reason, my lord. It can be for a mosque, it can be for school, it can be for hospital, it can be for Musafir Khana, it can be for Yatim Khana, several, because they say religious, charitable or pious purpose. Nobody has a right over the government land because the government being the owner of the land would mean the entire country is the owner of the land and the government holds the land in trust for and on behalf of each and every citizen. Number one. Number two, Wakf by user. Well, there are judgments that the government, even in case of a Wakf, that government can protect its property if it is declared to be a Wakf. There is a Supreme Court judgment. I'll not cite one paragraph from that. Lord, secondly, Lord, when we say Wakf by user, by definition, the property belongs to someone else. You have acquired right by continuous use. I hope I'm clear, my lords. Wakf other than Wakf by user, my property, I dedicate it to Allah, my lord, and it becomes a Wakf. But Wakf by user, by definition, means by long usage, it acquires the property, it acquires the character of a Wakf, and therefore necessarily either a private property is used for a long period or a government property is used for a long period. Now, my lord, the question is how to decide whether this is a government land or not. For the time being, my lord, forget Wakf by user. But suppose there is a building standing on the property, which, my lord, can be a government property. It can be a residential building, it can be an industrial building, it can be a temple, it can be anything. The question I'm posing to myself is, my lord, can the government not examine that whether this property belongs to the government I'm holding in trust for and on behalf of 140 crore citizens or not? Lord, that is provided for in 3C, which your lordship put.
That is what their condition is.
Yes.
That maybe an officer above the collector.
Correct, Manoj.
So
I'll answer that, Manoj.
He is a government officer.
Yes.
So government deciding its own claim.
I'll answer that. I'm conscious.
And given a finality to that.
My lord, that is where I may say, my lord, with the sense of responsibility, it was not only just misleading argument, but it was a false argument, and I'll demonstrate that. My lord, what happens, my lord, when a revenue correction process starts, revenue records are being corrected, the revenue authorities decide whether it is a government land or not. But revenue authorities decide only for the purpose of revenue records and correction of records. They cannot decide the title. I'll come to that, my lord. I'll satisfy your lordships. And it is not final. My lord, repeatedly your lordships were told that there is complete absence of access to justice. I am a judge in my own cause and my order is final. I'll demonstrate that, my lord, that to be not just misleading but false. Please come to page 12 of my written submissions where I have quoted 3C. Now this is the identification. My lord, initial bill was that the collector would decide, because on land revenue laws, your lordships are aware, every state has a land revenue law, and the collector decides whether the government is the owner of the property or it's a private property. But the objection raised by many was that collector himself is the custodian in this district for the revenue purposes, for the purpose of government property. So he will be a judge in his own cause. That was the arguments against the collector being the adjudicator, and therefore it was suggested by JPC that let somebody else be the designated officer. Please have a look, my lord. Any government property identified or declared as Wakf property before or after the commencement of this act shall not be deemed to be a Wakf property. Now, 2, this will have to be read with 2. If any question arises as to whether any such property is a government property, the state government may by notification designate an officer above the rank of the collector, hereinafter referred to as the designated officer, who shall conduct an inquiry as per law and determine whether such property is a government property or not, and submit his report to the state government. Now, please see, provided that such property shall not be treated as Wakf property till the designated officer submits his report. I'll come to, my lord, what is the intent. If your lordship wants to delete this, please delete it. It's in their interest, my lord, that this provision is made. And I'll demonstrate that.
So delete what, entire section 3C?
No. The proviso they were objecting to, the proviso.
But then, no, they are not only objecting to proviso, they are objecting to the entire section.
No, I said this when I read proviso, but I understand. No, they are not for entire section. 3. In case the designated officer determines the property to be a government property, he shall make necessary corrections in revenue record and submit a report in this regard to the government. The state government shall, on receipt of the report of the designated officer, direct the board, that is Wakf board, to make appropriate corrections in the record. Lord, the only consequence of the exercise undertaken by the designated officer under 3C will be that revenue record and the board record will be modified, will be corrected. Now, please come to, my lord, I will answer that question, my lord, but before I answer.
1 minute, first let the...
Yes, I'm sorry. There is a remedy. इसमें नहीं होगा.
So put the only consequence of exercise under section 3C,
Yes.
is correction of records and nothing further.
Correction of record of revenue record and the board record. Nothing further, and this is what I have said on affidavit which is served upon them, but nobody, my lord, brought to your lordship's notice while arguing that my land is taken away. Please have a look at, my lord, page.
What is the purpose? Then it will be only a paper entry.
It would be a paper entry if I want to establish, I means the government wants to establish its right of title, right of ownership. The government will have to file a suit for title. If, please have a, I'm reading my affidavit. Please have a look at page 95 of my affidavit. This, my lord, in all fairness, my lord, when affidavit is filed long back, should have been brought to your lordship's notice. Because the argument repeatedly made was that This is wholesale takeover of Waqf. First, revenue entries will be corrected and the entries in the board will be corrected so that if anyone is dealing with the trust property, he would know that as per revenue record, government is the owner and not the Waqf. Now, my lord, please come to page 95 of my counter, para 152.
Para?
152, page 95 of my counter. Yes. Kindly keep, my lord, my counter handy. Does your lordships get, my lord Justice MASIH get? It is further submitted that the function of the designated officer in this regard is limited. It is submitted that in case the officer's report states that the property is government property, the revenue record will be updated to reflect the same. It is submitted that the designated officer is not making a final determination of rights because it is an established principle that mutation in the revenue record is only evidence and but not conclusive of ownership, which should be evidence of possession. No, there is a typo. It is submitted that if the designated officer determines the property to be a government property under section 3C2, it would result in the government being reflected as the owner in the revenue record. Now, please see 153, very important. It is submitted that it would be open for the affected or aggrieved party in such case at any stage to approach the Wakf Tribunal under section 83(2) of the Act. It's not final. There is no denial of access to justice. I'll come to that section, my lord.
Which paragraph you are reading?
153, my lord, page 96. Lord, I'll just read again, my lord, 153. It is submitted that it will be open for the affected or aggrieved party in such a case at any stage, even if, my lord, entry is changed, to approach the Wakf Tribunal under section 83(2) of the Act. It is submitted that final determination with regard to the title would therefore be made by the Wakf Tribunal or in appeal by the Honorable High Court and the Honorable Supreme Court. It is submitted that the final rights of the parties would be subject to the court's decision. It is submitted that updating of the revenue records as provided for by section 30C2 and 30C3 ensures that the record of rights is accurately maintained. Now, my lord, please see section 83. Lord, to answer the argument, now, my lord, repeated arguments that my decision under 3C, that is, or designated,
The picture that is being painted
is final.
is that once the collector conducts an inquiry,
yes, ma'am.
the property will cease to be a work property.
Yes, ma'am.
And once the collector concludes an inquiry, the entire property will be taken away by the government.
No, my lord, it cannot be. It will have to be if we want to evict. It will have to be.
The eviction will have to be only in
accordance with law.
With due process of law.
Absolutely, my lord. Suppose, my lord, it's a municipal corporation's property which is encroached upon, and it is found to be a municipal corporation's property. There would be statutory provisions, and your lordship's judgment will come into play. If it is a government property without any title being determined, then, my lord, we will have to go for a title suit. I've said so on affidavit. But the repeated argument was that this determination under section 3C is final. There is no remedy.
No, not final. Not only final, but immediately they will lose the possession.
Exactly, my lord. Now, please see 83. Please see 83, my lord.
For according to you, the possession continues as it is, unless the recourse in accordance with law.
Obviously, my lord.
For taking possession or eviction, whatever.
And this is what I have said in my affidavit. I was waiting for them to show this to your lordships, my lord, but now I am showing, my lord. But please come to page 83. Section 83, my lord, section 80.
Do you expect this in the Supreme Court?
Lord, all three, my lord, at least have come from the High Court, my lord, and we had certain, my lord, rules.
Last 6 years, I have seen even the lines in the judgment being read, which are only
relevant to them. Selectively read. Selective reading. But kindly have section 83. Constitution of Tribunals.
Yes.
The state government shall, by notification in the official gazette, constitute as many tribunals as it may think fit for the determination of any dispute, question, or other matter relating to a Waqf or Waqf property, eviction of a tenant, or determination of rights and obligations of the lessor and the lessee of such property under this act, and define the local limits of jurisdiction. The proviso is not relevant. 2. Now kindly see, this confers the power. If 3C is passed, this is the remedy to an aggrieved party. It's a judicial review provided for by a tribunal.
So according to you, unless the proceedings as provided under section 83 are taken to logical end, there will be no eviction.
Can never be. I'll come to that. My lord, please have a, my lord, please see 83 first. 2. Any mutawalli person in any mutawalli, it should be comma, my lord, it's a typo. Any mutawalli person interested in the Waqf.
So it should be any comma, mutawalli comma.
Any person, mutawalli person,
sorry, again,
mutawalli comma, person interested in a Waqf or any other person aggrieved. Anyone. He need not, he may be just a beneficiary, he may be just a worshipper. Aggrieved by an order made under this act. My lord, this obviously includes 3C order. Or rules made thereunder may make an application within the time specified in this act, or where no such time has been specified, within such time as may be prescribed to the tribunal for determination of any dispute, question, or other matter relating to the Waqf. My lord, then please directly come to, my lord, 5, subsection 5, which is this tribunal, my lord. The tribunal shall be deemed to be a civil court and shall have the same powers as may be exercised by a civil court under the Code of Civil Procedure while trying a suit or executing a decree or order. Correct, my lord? Then 6. Notwithstanding anything contained in the Code of Civil Procedure, the tribunal shall follow such procedure as may be prescribed. The decision of the tribunal shall be binding upon the parties to the application, and it shall have the force of a decree made by a civil court. Now, most important, my lord.
You also refer to subsection 4.
Yes, my lord. 4. I'm sorry, I missed. Every tribunal shall consist of 3 members, 1 person who is or has been a district judge, who shall be the chairman, 1 person who is or has been an officer equivalent in the rank of joint secretary to the state government member, 1 person having knowledge of Muslim law and jurisprudence member. Provided that a tribunal established under this act prior to commencement of the 25 amendment shall continue to function and as such until expiry of the term of the office of the chairman and members thereof under this act. Lord, now please come to 8, subsection 8. The execution of any decision of the tribunal shall be made by the civil court to which such decision is sent for execution in accordance with the provisions of CPC. It has all powers of the civil court. Its order is treated as a decree of the civil court. It is executable by the civil court. But please see, my lord, this is what is introduced in 2025. This was not there up to today. That is subsection 9. Earlier it was, my lord, no appeal shall lie except in some cases. It was kind of a revisional jurisdiction. Now a full-fledged appeal to the High Court against this decision. Please see subsection 9.
earlier there was no provision for appeal.
There was a provision, my lord, which is at the bottom, but it was like a revision, call for record and examine validity, etc. Now, what is provided for is a full-fledged first appeal. My lord, please have a look at what was earlier, my lord, subsection 9. Because I cannot be selective in my reading, my lord. The government must assist fully. Your lordships would find in the book, my lord, the bottom.
Provided High Court may on its
No appeal shall lie against any decision or order, whether interim or otherwise, given or made by the tribunal. So the first finality was given. Then, provided that a High Court may, on its own motion or on an application of the board or any person aggrieved, call for and examine the records relating to any dispute, question or other matter which has been determined by the tribunal for the purpose of satisfying itself as to the correctness, legality or propriety of such determination, and may confirm, reverse or modify. It was like section 115 of CPC, akin to that, but now it is a full-fledged first appeal. And against which, my lord, depending upon, my lord, the High Court's jurisdiction, in some High Courts, if the first appeal is taken up by the learned single judge, then intra-court appeal also lies, where there is a latest patent, or my lord, SLP before your lordships. So it is absolutely wrong to say that 3C order is final. 3C order is not final. It is subject to judicial review, having layers of judicial adjudication available. Now, my lord, when your lordships are at page section 83, please read, my lord, 85 also. Hmm, 89.
It will not be a
Yes. No, please see section 85.
Shankaran, you are on this side.
Yes, I'm appearing for the board. We are in fact.
No, he is for one of the Waqf boards.
Yes. No,
Lord, everyone is not on the other side, my lord. Even in the community, my lord, I don't think they can claim.
We don't take it as a community or otherwise. We are only deciding what the matter is before us.
Obviously,
There's a fair balancing.
I'm not concerned with that.
Constitutionally, there's a fair balancing that's been done by the Amendment Act, is what I feel. Yes.
We'll have your assistance.
Yes.
My lord, do we reserve our arguments, my lord, on this, or will your lordship give us the right to reply?
We'll give you half an hour, but then this was.
My lord, because.
I'm reading provisions. What reply can you give?
One point.
No, and it is not as if that he is arguing something new. If there is already a foundation for that argument in the counter affidavit.
May clarify, my lord. For the future, Waqf by user is abolished. 3R1. And the proviso, my learned friend says, it will not be Waqf in the meantime. He says you can delete it. Now, my lord, Waqf, our point is, my lord, our point is, Waqf by user is abolished.
Mr. Dhawan, we did not permit Mr. Tushar Mehta to interrupt.
My lord, I apologize. My lord, I apologize.
So he was tempted quite a few times.
No,
Because, my lord, there were certain statements which were
my lord, I
peculiar.
stand admonished, my lord.
We are not
I
admitting.
apologize.
You are too senior to
No, my lord,
We are
I
only-
apologize.
Yeah, we are only reminding what we did with Mr. Mehta.
Only following his example, my
No,
lord.
we did not permit investment. We don't know about the other courts, but when he was trying to compete with the anxiety of that young girl, he's not saying today.
My lord, he is a master at all this, my lord. I'm only a novice.
So we did not permit him to be so anxious.
Lord, he is too senior, my lord, for me to respond. Though I can. Lord, now please see 85, section 85. No suit or other legal proceedings, your lordship gets, my lord. No suit or other legal proceedings shall lie in any civil court, revenue court, or any other authority in respect of any dispute, question, or other matter relating to any Wakf property or other matter which is required by or under this act to be determined by a tribunal. Now come back, my lord, to 3R, my lord, in my note. 3(1)R. I'm sorry, 3C. Sorry, 3C first, my lord. Provided that, my lord, kindly read, my lord, section, page 13 of my written submissions. They say that before you even adjudicate, my Wakf is taken away. That was the argument. That is the pitch at which the argument was made. Please see, my lord, proviso, page 13, the top line. Provided that such property shall not be, please mark, treated as Wakf property. Treated, my lord. The purpose is, if you wish to file a civil suit, your character as a Wakf property is kind of in suspension so that you can take remedy. It's not that the Wakf will be snatched, but the word used was that this is en masse taking over of the Wakf.
Wakf property.
It is capture of Wakf property. Yes, my lord, I'm thankful to my learned friend. The word used was wholesale capture of the Wakf. Only thing 3C does is deciding the revenue entries and the ownership right, correction of revenue record, correction of board record, and ultimately, my lord, it will be the competent court, my lord, or the tribunal which will decide the question, my lord. Now, my lord, coming back, please come to, my lord, 3RF. Now, it is
What you are trying to say on the basis of proviso is that it continues to be a Wakf.
It's not
but it
treated
cannot-
as a Wakf. Yes, my lord. So
Two aspects you have clarified. One, the possession continues as it is.
Yes, my lord. And if we
Second
want,
aspect is that the property continues to be Wakf, but not to be treated.
not to be treated, that embargo is lifted as a character. That's all.
It is a status quo as such.
Yes, no, it's not even status quo. They can exercise whatever court they want to go as if they are not a trust.
That in any case.
Suppose
Otherwise, there is a,
they want to alienate the property as a work property.
then they cannot.
They can't,
They cannot.
unless the dispute is decided by.
Yes, my lord, that is the purpose, because otherwise you alienate the moment the notice is received from the designated officer.
In a way, therefore, what my learned brother says is.
Correct.
Still,
Status quo is.
Status quo,
Yes,
till
correct.
the rights are adjudicated by a competent forum.
Correct. Because it's till it is decided whether it's a government property or not, how can that be transferred or encumbered upon? My lord, now kindly come back, my lord, to page 4, the proviso, my lord, which is under challenge. And I may answer, yes, from this amendment date, Wakf by user is not a permissible mode of creating Wakf. That's the legislative policy. Now, any Wakf can be created henceforth prospectively only by a registered Wakf deed. But past Wakf by users are saved, provided they are registered. And with an exception, if it is a private dispute, then obviously nobody can object, my lord. If it's my private property, I have filed a suit.
Dispute will also, in view of 83 and 85.
Yes.
Such a dispute will also have to go to the tribunal.
It will have to be it will have to go to the tribunal, my lords. But even, my lord, there are some suits pending. There may be some suits pending. So I have specifically said in my affidavit that any such dispute with private individuals will depend upon the outcome by the competent forum, judicial forum.
So again, even according to, in your view, even according to proviso also, the possession would not be taken unless it is decided by a competent forum under 83.
And or in accordance with law. Suppose, my lord, it is decided that the property is that of a municipal corporation. Then there would be a law governing the possession. There would be a municipal corporation law or a municipality law, and thereafter your lordship's judgment will take over. Notice by registered post, this, that, and others, my lord. So possession will not be and cannot be taken over except in accordance with law. Not by operation of 3C or the proviso to 3C. It was a deliberately misunderstood argument to create a confusion. I don't think, my lord, even they have understood it that way. It was an alarming argument that this is the major, manifestly that it is being snatched away. That was, my lord, the argument.
Wholesale
captured.
Wholesale capturing.
Wholesale capturing, my lord. But that is the reason, my lord. Why? My lord, your lordships generally do not entertain a petition till the statute operates. Once the statute operates, your lordship comes to know what is the intention of the statute. And some aggrieved party will come. These are all, my lord, on academic level, we are discussing what is the meaning of this section, that section. Your lordships are aware, Kusum Ingot's judgment, that there cannot be any academic challenge without an aggrieved party before the court. But I'm answering, my lord, on merits. I'm not going on that technicality because I have an answer on merits. Now, my lord, please see, the only exception which is made is only registered Waqf by user will be protected. My lord, please come to page 12 of my counter. I'm sorry, my lord, page. No, not 12, my lord. Please come to.
How much is your estimate?
My lord, I'll be by 115, my lords.
Who are others?
My lord, others are also there, my lord. But, my lord, even if we'll conclude by today, my lord.
If something remains, we are not going to repeat anything. That is absolutely no way. If something remains,
we have heard this sentence.
No, but I am very particular about, with all due respect and humility.
No, my lord.
In any case, suppose even if you complete by say 3:30,
then also, my lord,
they can have.
I'll give sufficient time, my lords. I would request my colleagues also to assist your lordship. Your lordship must get assistance from all quarters.
What discharge for the day?
I want to start with now please come to, my lord, my affidavit on registration part. My lord, the argument was that registration was never mandatory. My lord, that was the first argument. Your lordships were pleased to record it. The second argument was
there are no consequences for non-registration.
Consequences provided. Now, my lord, I have, my lord, gone to the root of the problem which British government tried to solve, Indian government tried to solve throughout. Please come to page 16. And, my lord, this is the statement of objection reasons of Mussalman Wakf Act 1923. Very crucial, very important, my lord, for your lordship's assistance. My lord, 1913, my learned friend said that 1913 is the first amendment, first enactment. Lord, it was not there. Waqf al-Aulad was recognized. That's all. It was not an enactment in that sense. This is the first enactment governing regulation and administration of Waqf properties. And kindly, my lord, allow me to read the statement of objects and reasons. and your lordships would find, my lord, the answer to why 5 years. Practicing Muslim. This menace has been going on since 102 years. Please have a look at, my lord, page 16. Does your lordships get, my lord, page 16 of my counter, statement of objects and reasons. My lord, may I read? May I read? The object of the present bill is sufficiently indicated by the preamble to the bill. For several years past, there has been a growing feeling amongst Mohammedan community throughout the country that the numerous endowments which have been or are being made daily by pious and public-spirited Mohammedans are being wasted or systematically misappropriated by those into whose hands the trust may have come in the course of time. Please mark this, my lord. Instances of such misuse of trust property are unfortunately so very common that a Wakf endowment has now come to be regarded by the public as only a clever device to tie up the property in order to defeat creditors and generally to evade the law under the cloak of a plausible dedication to the Almighty. My learned friend, my lord, is entitled to recover 1 lakh.
Once, is there a provision that once the property is declared as a work property that it can't be?
Yes, it is dedicated to Allah. So, my lord, my learned friend is supposed to, my lord, recover 1 crore from me. He files a suit. If his suit is decreed, it can be, my lord, realized from my property. I declare my property as well.
Declare it to be a work property, it can't be.
It can't be. And for that purpose, there is a possibility that I will say that I have converted myself into Islam.
Like
marriage.
Oh, Goa marriage, yes.
Like marriage. Therefore, I'll come to that, my lord. It's not as if that you will have to establish that you are offering 5 namaz and you are not drinking wine, etc. That's not the thing. And I can tell your lordships, Sharia Act, which governs all Muslims in their personal law, has section 3 that you have to establish that you are a Muslim. Only then Sharia Act applies. I'll come to that. But please have a look at, my lord, further. This is what, my lord, the problem the country faced in 1923. My lord, Waqf definition is, Waqf means the permanent dedication by any person. It is a permanent dedication to Almighty Allah. It's not a gift like Hindu.
So therefore, compulsory registration, according to you, is to avoid this menace.
This menace and mismanagement of Waqf properties comes further. And this is not, I have not written. This is in 1923, the British government, my lord, when this act came for the first time, my lord, please have a look at, my lord, further. In some cases, mutawallis are persons who are utterly unfit to carry on the administration of Waqf and who, by their moral delinquencies, bring discredit not merely on the endowment, but on the community itself. It is believed that the feeling is unanimous that some steps should be taken in order that incompetent and unscrupulous mutawallis may be checked in their career of waste and management, mismanagement, and that the endowments themselves may be appropriated to the purpose for which they had been originally dedicated. In some cases, please mark this, the purpose of registration. In some cases, difficulties have arisen in finding out whether any particular properties are really subject to Waqf or not. There are numerous Waqf properties all over the country, unknown to the public, which the mutawallis are treating their own property and dealing with in any way they think fit or necessary. Please see, my lord, further. It therefore seems that there should be a system of compulsory registration requiring a mutawalli to notify to some responsible officer, not merely about the fact of the Waqf of which he is the mutawalli, but also the nature and extent and other incidents of the endowment. Further, even a Waqf is well known and mutawalli is obviously thoroughly incompetent to carry on his duties, the public find a difficulty in instituting suits to remove him from his post by reason of the cumbersome procedure laid down in the Code of Civil Procedure, it is with a view to facilitate the institution of such suits that a provision has been made in the bill. Lastly, there appears to be a general consensus of opinion among Mohammedans throughout the country that there should be some responsible officer who may go about and find for himself whether various Waqf properties scattered throughout the country are being properly managed or not. My lord, the argument was that Raji, it's not our responsibility to register. It would be the survey commissioner who will survey. I will demonstrate from 1923 onwards, there are 3 tiers of responsibility. First, if I am a Waqf, it is my responsibility to get it registered. If I don't do it, there was a penalty provided. Second, with a view to ensure that unscrupulous people by...
Whether 1923 Act also had a provision for registration.
100%, I am going to show that.
Earlier, Mr. Kapil Sibal made an argument that in 1923 Act also that there was a registration, but then subsequently he said from 1954, that is what we are recorded.
Please have a, my lord, I have quoted sections. I am reading from the sections.
I argued that this was the first time that registration came in 1954.
My lord, I am reading from the sections, my lord. Yes, please have a look at, my lord, section 3. Page 70, my lord, 17, section 3. Within 6 months from the commencement of this act, Lord, kindly note one fact while reading this section, and that is very, very crucial. Lord, there is a campaign going on in the country that 100 years old Waqf properties are there. From where do we get the papers? Hum kagaz kahan se layenge? That's the narrative which is built. Argued here also. And I will show kagaz kabhi zaruri nahi the. Because the law knew that there can be old properties where there may not be any documents available. Please have a look at section 3, my lord, in this light. How, my lord, a misleading campaign or, my lord, a kind of a narrative is being built. Obligation to furnish particulars relating to Waqf. Within 6 months from the commencement of this act, every mutawalli shall furnish to the court, not, my lord, officer, earlier it was court, within the local limits of whose jurisdiction the property of the Waqf of which is the mutawalli is situated, or to any one of the 2 or more such courts, a statement containing the following particulars, namely, no documents, my lord, the Waqf deed is not required. Please see, a description of the Waqf property is sufficient for identification. You can always say this survey number, this gully, this mohalla, etc. Description which is sufficient to identify the property. B, the gross annual income from such property. In 1923, within 6 months when you are going before the court, you will have the accounts at least. It's not that 200 years back you have to go. The account of the income of the property, the gross amount of such income which has been collected during the 5 years preceding the date on which the statement is furnished, or of the period which has elapsed since the creation of the Waqf, whichever is shorter. If you say Waqf was created 100 years, then you provide only for last 5 years. The amount of government revenue and cesses and all rents annually payable in respect...
5 years, suppose if they claim that the work is of 100 years old,
100 years,
then you have to only give the accounts of 5 years.
Last 5 years. It was very reasonable. And nobody said that Waqf deed is necessary. The argument was that who will have the Waqf deed? Now please see. An estimate of expenses annually incurred in the realization of the income of the Waqf property based on such details as are available of any such expenses incurred within the period of which particulars under clause C relate. Then amount set apart, my lord, for salary, etc. Please see 2. Every such statement shall be, it was not, my lord, a mere formality. There was a sanctity attached by, my lord, by the act. Every such statement shall be accompanied by a copy of the deed or instrument creating the Wakf, comma, or if no such deed or instrument has been executed or a copy thereof cannot be obtained, shall contain full particulars as far as they are known to the mutawalli of the origin, nature, and object. Look, very relevant for the user. The other side said that where do we get the document? The 1923 says document, if you have, provide, otherwise, provide whatever you know about the origin. That this person started this practice, this person started this particular premises, whatever you is within your knowledge. Then third, where a Wakf is created after commencement of this act, that is after 1923, or we are not concerned, my lord, please come to thereafter. The statement referred to in subsection 1 shall be furnished in the case referred to in clause A within 6 months of the date on which the Wakf is created, or if it has been created by a written document of the date on which such document is executed. So if it is created after 1923, within 6 months, you have to go and inform about this before the court, so that there is a contemporaneous record. You can't just say that this is going on by usurer since 100 years. Now, please come to 4. My lord, what would happen when it goes before the court? Court would publish it, so that if it is my property and my property is being shown as a Wakf, I'll have a right to object that this is my personal property. It can't be a Wakf. Please have a look, my lord. Section 4, page 19. When any statement has been furnished under section 3, the court shall cause notice of the furnishing thereof to be affixed in some conspicuous place in the courthouse and to be published in such other manner, if any as may be prescribed, and thereafter any person may apply to the court by a petition in writing, accompanied by the prescribed fee for the issue of an order requiring the mutawalli to furnish further particulars and documents. I will have a right of objecting. Now, please come to, my lord, statement of accounts. Lord,
sorry, my lord, for not being here.
Your turn is yet to come.
Pro bono matter I have to do. Follow that, and therefore I apologize.
You should follow Dr. Singhvi.
No, it was only that exception. Well, the Ashoka.
You don't require permission to go out.
I apologize.
Lord, 5. Statement of accounts were to be filed in the court every year. This was a statutory mandate. Then, my lord, 6. I'm not reading it, but my lord, your lordships can take it from me. This required a statutory audit by a chartered accountant in 1923 if your income exceeds a particular amount, and other audit, my lord, if it is less than the amount. Then, my lord, how will you file that application before the court? I'm showing the sanctity of the statute, my lord. Please come to page 21, para 8, section 8. When I file, my lord, as a mutawalli before the court, this is what I'm supposed to do. Every statement of particulars furnished under section 3 or section 4 and every statement of accounts furnished under section 5 shall be written in the language of the court which it is furnished, in which to which.
Not necessary. What was
this is more than registration.
But what was provided was making a statement. So, technically, it may be right.
Not technically also, my lord. It is something more than, my lord, registration. You are going to the court and court is thereafter taking over. My lord, my learned friend, my lord, wants me to show, my lord, and I have missed in my affidavit, section 9. I'll just read. Your lordship did not take, my lord. It's not there. I'll just read, my lord. Section 9 of this very act, 1923 act. Inspection and copies. This is where registration comes. The court registers it in its register, the court's register. Any person shall, with the permission of the court and on payment of the prescribed fee at any time at which the court is open, be entitled to inspect in the prescribed manner or to obtain a copy of any statement of particulars or any document furnished to the court under section 3 or section 4 or any statement of accounts under 5, so and so, so and so.
So in the public domain.
This remains with the court and I can get copies. It's more than registration. And my lord, after my lord, initially the petitioner said there is no consequence provided. Thereafter, my lord, they changed their position and they said that there is some penalty, but it is penalty.
According to them, it is only for Mutawali.
For Mutawali, but the trust
Waqf
Waqf would continue. So after 1 year, another Mutawali can be punished, but the Waqf continues. After a few years, another Mutawali will be punished, but the Waqf will continue. That's not, in my respectful submission, an absurd way of reading any statute. Now,
No, but in any case, it is not provided that the work will not continue or it will cease to be a work. That's not provided. As a matter of fact, in the provision.
as a matter, yes, but can you see the
Yes,
object?
the consequences are that the Matrimonial is.
And object is that every Waqf should be in public domain so that public knows about.
That section 9 says.
Yes. Now, my lord, come to, my lord, I must say, my lord, in 1923, my lord, Act, Waqf by usurer is not there. But that was a concept well known. To just show that even in 1923, there was a concept of Waqf by usurer at page 22. I have quoted, my lord, a section of Bengal Wakf Act, 1934, which defined Waqf by usurer. So it was not as if Waqf by usurer was a completely alien or an unknown concept in 1923.
1934.
Yes. But 1934, Waqf by usurer has to start, my lord, much before 1934. But interestingly, this Act, 1934 Act, was challenged before Calcutta High Court on almost similar grounds and upheld. But I am not going into it, because we are arguing for interim relief. Whether would your lordships consider staying this provision? Now, my lord, comes 1954 Act. This is the first enactment after independence. Now comes 1954, Act of 1954, page 22 of my reply notes. Now, my lord, one more layer is added because the legislature, my lord, experienced that Waqfs are not getting themselves registered. So they are not coming within the fold of regulatory mechanism of the Waqf Act. But registration has, my lord, what is the significance of registration? I pose a question to myself. So that you are regulated by the regulatory mechanism of the Act and you do not mismanage the Act. You do not deal with third parties and cheat them, etc., etc. And if you want to transfer a property, you need somebody's permission. Your accounts are audited, your accounts are being seen by the Waqf board, etc. And the board is only a secular administrative supervisory control board. I'll come to that. Please have a look at, my lord, for the first time, this survey concept was introduced. That first, it is your responsibility to get it registered. But if you do not, then second, there is a second option, my lord. Preliminary survey of Waqf. My lord, kindly come to subsection 3.
Section 3, therefore, is the same. Section 3, which is the Waqf.
Section 3 is now definition, my lord. Now, my lord, the court part goes. Now registration is with Waqf board. For the first time in 54, Waqf board came to be created. Earlier, the administration was with the court. But maybe they may have found that court is otherwise overburdened rather than taking supervisory control over Waqf. There was a separate mechanism provided. Page 23, section 4, subsection 3. The survey commissioner shall, after making such inquiry as he may consider necessary, submit his report in respect of Waqf existing at the date of commencement of this Act in the state or any part thereof to the state government, containing the following particulars, namely, the number of Waqf, the nature and objects of each Waqf. So first, if you are a Waqf by user, you should have got yourself registered. Second, if you are a Waqf by user and you have chose not to get yourself registered, you will be caught at this stage. The commissioner will catch you. Now kindly directly come to subsection 5. If during any such inquiry, any dispute arises as to whether a particular Waqf is a Shia Waqf, your lordship can skip. 6. The state government may by notification in the official gazette direct the survey commissioner to make a second or subsequent survey of Waqf properties in the state. If the state government finds that no, there is something missing, you again do it. Lord, now kindly come to section 5. Section 5. Publication of list of Waqfs. On receipt of a report under subsection 3 of section 4, the state government shall forward a copy of the same to the board. The board shall examine the report forwarded to it under subsection 1 and publish in the official gazette a list of Waqfs in the state, or as the case may be, the part of the state, whether in existence at the commencement of this act or coming into existence thereafter, to which the report relates. Why? So that disputes can be raised. That this is my property which is declared to be a Waqf property. This was the significance of registration. Now please see dispute regarding Waqfs. If any question arises whether a particular property specified as Waqf property in a list of Waqfs published under subsection 2 of section 5 is a Waqf property or not, or whether a Waqf specified in such list is a Shia or Sunni Waqf, the board or the Mutawalli of the Waqf or any person interested therein. If it is my property declared, then I am interested person, may institute a suit in a civil court of competent jurisdiction for decision on the question, and the decision of the civil court in respect of such matter shall be final. Now, my lord, see the explanation. Lord, kindly see subsection 4 at page 26. The list of Waqf published under subsection 2 of section 5 shall, unless it is modified in pursuance of a decision of the civil court, be final and continue and conclusive. Then, my lord, 6A is a power of the tribunal to determine the dispute, whether it's a Waqf property or not, my lord. Please come to 28 now. Section 25.
So there are two mechanisms.
Yes. First is my duty to register.
Under the 54 Act, so a suit as well as a tribunal were both functioning.
That was a suit only, my lord. Yes, my lord. Yes, your lordship.
6A power of tribunal.
6A, yes, my lord. 6A is a power of the tribunal. Your lordships are right.
It appears they added through an amendment later.
It is added, my lord, in 1984. My lord, 84 amendment has a very interesting history I am going to show. That was very, very relevant, my lord, to show. My lord, the section 6A itself makes it clear.
Ideally, they ought to have deleted 6.
Yes.
The provisions are almost parliamentary.
But I'll come to that. This was thereafter not implemented. I'll give the reason why.
It has to come effect from the date on which this will be notified. So that notification might not have come.
It did not come, and I'll show, my lord, why it did not come. Lord, now come to page 28. Section 25, registration. Now, an independent duty to get yourself registered. You cannot rely upon the survey commissioner's survey. you have an independent duty to get yourself registered because there is a penalty provided. Every Waqf, whether created before or after the commencement of this act, shall be registered at the office of Waqf Commissioner. Before, so even if it is 100 years old, if you have missed the 1923 route, then still you can register. Then application for registration shall be made by the Mutawalli, provided that such application, please mark this, such application may be made by the Waqif or his descendants or a beneficiary of the Waqf or any Muslim belonging to the sect to which the Waqf belongs. So not just Mutawalli, the registration had this significance that anyone should come and get it registered so that it comes within the regulatory framework of this act. Now, my lord, please see 7, subsection 7. My lord, now kindly see particulars. Again, my lord, that from where do we get the documents? The narrative which is built. Please see subsection 3. An application for registration of the registration shall be made in such form and manner and at such place as the Waqf Commissioner may prescribe and shall contain the following particulars so far as possible. Please see, a description of Waqf property sufficient for identification. That's all, and the remaining is same. Accounts, this, that, audit, who are the beneficiaries, what are the salaries you are paying, not Waqf deed or any other document. Now, please see 7, my lord. On receipt of an application for registration, the Waqf Commissioner may, before registration of the Waqf, make such inquiries as he thinks fit in respect of genuineness and validity of the application and correctness of any particular. My lord, suppose I go and say that this property is being used as, my lord, kindly mark this. This is important. This property is being used as Waqf by user. It is his duty to go and examine whether that claim is right or I am raising it today. Whether it is being used as a Waqf by user since time immemorial or I am raising some false plea today and the reason is relevant. Waqf by user has to be by definition on the land not belonging to the Waqf. It has to be someone else's land. By definition, I get a right of user from somebody's land, either a private land or a government. Therefore, this requirement that application comes, you will have to inquire. And 8 is the window is given that though you were responsible to get it registered in 23, you have not done so till 54, please come to 8. In case of Waqf created before commencement of this act, it can be 100 years old, it can be 50 years old, whatever. Every application for registration shall be made within 3 months from such commencement, and in case of Waqfs created after such commencement, within 3 months. So a window is given that even if you have missed registration, please get it registered.
Under the 23 Act, it was 6 months, now it is 3 months.
Yes. So that even if you have missed 23, now get it registered within 6. Now please come to, my lord, section 26. There is a register of Waqf. The Waqf Commissioner shall maintain a register of Waqf which shall contain in respect of each Waqf copies of Waqf deeds when available and the following particulars, namely, A is enough, my lord, the class of the Waqf. He will have to mention that this is Waqf by user, Waqf al-Aulad, whatever. But we are concerned with Waqf by user, he has to mention this. Now, please see, my lord, the third layer was added, that if the commissioner also misses, the Waqf also does not discharge its mandatory obligation of registration, then the power was given to the board. Section 27. Please mark, my lord. The board may, your lordships are on page 31. The board may itself collect information regarding any property which it has reason to believe to be Waqf property, and if any question arises whether a particular Waqf property is a Waqf property or not, whether a Waqf is a Sunni or Shia Waqf, it may, after making such inquiry as it deems fit, decide the question. So third layer, the argument was that it was the duty of the Waqf board to decide whether I'm a Waqf or not. No, your duty under section 25 to register it. Second layer, the survey commissioner independently will examine whether somebody is missing. And third layer, this. Now, Lord, please see 3. Where board has any reason to believe, that this is important, that any property of any trust or society registered in pursuance to Indian Trust Act or under the Societies Registration Act or under any other act is a Waqf property. So even if a Muslim creates a trust, what happens, Lord? The board may, notwithstanding anything contained in such act, that is Indian Trust Act, hold an inquiry in regard to such property, and if after such inquiry, the board is satisfied that such property is Waqf property, call upon the trust or the society, as the case may be, either to register such property under this act as Waqf property or show cause why such property should not be registered. So even if it is a registered trust, the board will call and say that now register it as a Waqf. The choice was not there. And I'll come to that proviso to section 1. This is taken. The proviso to section 2. That now if a Muslim doesn't want to create a Waqf, but still wants to do charity, he can create a trust. It's an empowering, enabling provision. I'll come to that, my lords. Now please see, my lord, most important, 28. Power to cause registration of Waqf and to amend the register. Well, I'm on page 32, section 28.
Yes, we have it.
Waqf commissioner may direct a mutawalli to apply for the registration of a Waqf or to supply any information regarding a Waqf, or may himself cause a Waqf to be registered, or may at any time amend the register of Waqfs. He can direct that you get it registered, or I will myself register it. And the penalty, my lord, if a mutawalli fails to apply for registration, then, my lord, please come to A, somewhere in the middle. If a mutawalli omits or fails with a view to concealing the existence of a Waqf to apply for its registration under this act, in case of Waqf created before commencement of the 1984 Act within the period specified thereof in subsection 8 of section 25, or within a period of, my lord, 1 window is given. Again, but the penal provision. Now, my lord, again, my lord, the government found, this is crucial, why registration is necessary, and this is not even brought to your lordship's notice by the petitioners. My lord, government found that still there is maladministration going on in the trust. Registration is not taking place, so that they are not under the statutory regulatory mechanism of the act, and properties are being dealt with the whatever manner in which the mutawalli, etc., or even the board is doing. So the central government appointed a committee in 1976.
Para 53.
Para 53, my lord. The 3 members' names, my lord, I have given, Sayyid Ahmad, etc. Now, please see, my lord, what was their report, which is relevant for the present purpose. The said committee was also very clear that concealment of Waqf and its willful non-registration is a serious issue. This is the reason why the proviso says only registered Waqf by users are protected, not unregistered Waqf by users. In that context, please read, my lord, the finding of this committee, appointed by the central government in 1976.
76?
So 1976. This report is 1976. And something interesting, I'll come, my lord. The report was implemented. A law was passed, and the law was not given effect to, and I'll show the reason why.
Yes.
Now, my lord, this is the findings of the committee. Deliberate concealing of Waqf. My lord, this is the committee's finding. This is not my submission. Committee's findings are quoted. Deliberate concealing of Waqfs and willful failure to have them registered is a deeply prevalent malady affecting the administration of Waqf. Attaching the highest importance to this matter, we have separately provided for imprisonment in such cases as a punitive measure. We consider that a carrot and stick policy is also required in the matter, dangling the carrot wherever possible and using the stick wherever it becomes necessary. Please mark this now, my lord, and my lord, bear this in mind. We consider that in the implementation of this policy, we have a state salutary provision under section 31 of the Bombay Public Trust Act. Your lordships would recall yesterday, they said that registered, if it is not registered, my right to go to the court is taken away. Your lordships recollects that? Kindly bear that in mind and read further. Bombay Public Trust Act. Bombay, all Trust Act has this provision. If you are not registered, you cannot file a suit. And the committee records that. Bombay Public Trust Act 1950, which bars the hearing of any suit in respect of a public trust which has not been registered under the Act. We consider that a similar provision is necessary in the Central Wakf Act of 1954, and no mutawalli who has failed to have Waqf registered as required under the Central Wakf Act should be provided with the facility of enforcing any right in a court of law unless he has duly registered his Waqf as required under this Act. We therefore recommend that a fresh section 55A may be added to the Central Wakf Act on the following lines. No suit to enforce a right on behalf of a Waqf which has not been registered under this Act shall be heard or decided in any court or tribunal. The provisions of subsection 1 shall apply to a claim of set-off or other proceedings to enforce a right on behalf of such Waqf. Now, this is, my lord, brought in 2025, but the history in between is interesting.
From 1976 to 25.
But in the meanwhile, the parliament amended it. It's very interesting, my lord. Please see. Based upon this recommendation, the parliament amended the Wakf Act by Wakf Amendment Act 1984, providing for the following amendment inserted in section 55E. My lord, the same, that that you cannot file a suit. Now, please come to, my lord, take the book, my lord, this Wakf Act. My lord, this was passed by parliament. 55A is a section passed by the parliament. It was not brought into effect. And please see the statement of objects and reasons where
with effect from a date to be notified. So that date was not notified.
Why? We kindly have a look. Look, there were two amendments made in 84.
6A and 55E.
No, the third amendment. Third amendment was
6A was also sought to be brought by the
brought by. But the third amendment was period of limitation. If it is Waqf property and I want to claim adverse possession as a Waqf, then earlier there used to be no period. It was prescribed as 30 years and 12 years for private party. Then this provision that if you are not registered, you will not file a suit. Passed by the parliament, not given effect to, my lord, please see statement of objects and reasons. The actual working, your lordship gets, my lord.
Which page?
My lord, same. My lord.
Same book.
Same book, my lord, page 1.
Of 2005.
This is 95. Yes. Lord, it's earlier known as Wakf Act 1995. That's the title, my lord. Statement of objects and reasons. My lord, page 1, my lord, your lordships are possibly, my lord, the Chief Justice is much ahead.
25 amendment or?
No, my lord, 20. I want to show the statement of objects and reasons in 95 Act.
95.
95. My lord, Act is the same, 25, only name is changed.
This is immediately after the index.
Yeah, yes, my lord. The title would be this, my lord.
Waqf Amendment Act.
Earlier known as Wakf Act, 1995. If I can, my lord, give me another copy.
I can give.
Maybe you have a different book.
Lord, I have a copy, my lord. I have another copy.
If you have one copy, I can give another one.
So we can share it.
Different, pagination may be different. Ah, okay. My lord, I may clarify, there are no two acts, 95 Act and 25 Act.
Right, just see the you've seen that.
Lord, your lordships may have this, Lord, another copy, may kindly have this.
Yes, we have it, yes. After Roman page 25, that's one there.
Page one at the foot of the page.
Yes.
Lord, statement of objects and reasons. Your lordship gets, my lord, in the middle, statement of objections.
Yes, sort of 95 Act.
Yes. The actual working of the Wakf Act 1954 had brought out many deficiencies in it, as also the setup of Wakf boards, especially their powers of superintendence and control over the management of individual works. To clarify some of these matters, the Act had to be amended 3 times, so and so, so and so, so and so. Now, please mark. Comprehensive amendments to the Wakf Act were made by the Wakf Amendment Act 1984, which were based largely on the recommendations of the Wakf Inquiry Committee set up in December 70. My lord, I read it, the report, my lord, this is the committee, which gave in 76. To inquire into administration of Wakf at all levels and in response to a demand made in Parliament by members during discussion on the Wakf Amendment Bill 1969. Only 2 provisions of mark this, my lord. Only 2 provisions of 1984 Act could, however, be enforced because of strong opposition to its various provisions from the Muslim community. The 2 provisions related to increasing the period of limitation for filing suits in respect of Wakf properties in adverse possession from 12 years to 30 years, and application of provisions of Wakf Act to the evacuee property. Rest of the provisions were not implemented. The provision which I have shown that if you are not registered, you will not be able to file a suit was passed by Parliament in Amendment Act of 1984. It was not brought into force. Now, my lord, it came in 1995.
1 minute.
And I'll show, my lord. Therefore, my lord, in this statement of objection reasons, they mention
The second number.
But the first one included. Well, not included. The first one did not include. The period of limitation. 3 years. Introduce limitation, that's completely.
Yes.
Lord, I must tell your lordships, and I'll take your lordships to that. This provision was never implemented. When 95 Act came into force, this provision was inserted as Section 87 in 95. As I have informed your lordships, in November 2013, the amendment was brought and this provision was again deleted. November 2013.
Brought
in 95, brought first in 84, did not implement. Thereafter, the new act comes, but 1995 is a new act with this provision as Section 87, which remained in force till 2013. And 2013 November, few months before the nation was to go to election, there were major amendments made and this provision was deleted, which was not implemented under the pressure of Muslim community as mentioned in the statement of objection reasons. Now, your lordships will kindly see the Wakf Act 1995 comes into force, page 37. Lord, I'll not read everything. but the scheme remains the same. 3R defines Waqf means, my lord, one, Waqf by user. Very interestingly, but such Waqf shall not cease to be a Waqf by reason only of the user having been seized. If it is registered in 2023, hypothetically as Waqf by user, even if that use has stopped, it continues to be Waqf by user. That was the section. This section now goes with prospective effect, with an exception that if it is registered Waqf by user, not subject matter of dispute in any court, and if it is a government property. Now kindly see, my lord, page 38, section 4. My lord, same, even in 1995, Waqf deed or any document which they say from where would we get was not mandatory. Then, my lord, preliminary survey. Then, my lord, section 5.
What is Awqaf?
Awqaf is, my lord, plural of Waqf. My lord, in 95, somewhere thereafter, 2013, it was amended in 2013. Waqf means single Waqf. Awqaf means plural. That's, my lord, Urdu. That is, hal becomes halat. Sawal becomes sawalat. Like, Lord, now section 5, publication of list of Waqf. My lord, now publication of list of Waqf, my lord, a very interesting provision was inserted. Page 40, section 5, subsection 3. When, my lord, the survey commissioner identifies some Waqf which is not registered deliberately, he will do this. He will inform the revenue authorities. The revenue authorities shall include the list of Awqaf referred to in subsection 2 while updating the land records, and 2, take into consideration the list of Awqaf referred to in subsection 2 while deciding mutation in the land record. The state government shall maintain a record of the list published under subsection 2 from time to time. It is submitted. My lord, this is my contention. Please mark this. Section 5 requiring publication clearly had 3 objects. In 95, to put everyone to notice that a particular property is declared as Waqf so as to enable an affected aggrieved party to challenge it. That you have declared my property to be a Waqf. Second, the claim of there being a Waqf is recorded in contemporaneous land record so that owner of every land, if the Waqf is not real owner, come to know about it and take recourse to law. And third, no person or entity can claim existence of Waqf if it is not registered. My lord, what would we do if somebody, my lord, says that I never registered the Waqf, but in 2024, there was a Waqf by user? Meaning thereby, you have not discharged your duty under 1923 Act. The survey commissioner did not discharge his duty under 1954 Act. The board did not discharge its duty under 1954 Act. Again, you did not discharge your duty in 95 Act. The survey commissioner also did not do it, and board also did not do it. Meaning thereby, it is a fictitious claim. Unless registered, it will not be accepted. That the legislative policy, and the limited point today is whether would your lordship like to consider staying that provision. If there is a reasonable object to be achieved, there is a nexus with the object of.
Yesterday only we said in the beginning that there is a presumption with regard to the constitutionality, and it is.
Yes, yes, ma'am. Now please see, my lord, section 40.
2 o'clock. Conclude by.
And then, my lord, everyone, my lord, would assist.
By 3, my lords. If he concludes by 3, there are other counsel. I hope they finish by 3:30 then, my lords. Otherwise.
See, I am not, my lord, not raising any new argument. I am reading.
No, I'm not objecting. I am not. I'm not objecting.
What was the record? You should have read, according to me.
Not objecting.
He was also, he had to complete within the time limited.
Certainly, I am not repeating myself.
in case you don't get time.
That's
today,
all, Malad, so that.
we'll give you half an hour to talk.
Whatever, Malad, so that if, because I should get some time to reply to.
Yes, we will give you half an hour.
Yes, good enough, good enough.
Obliged. Lord, with the Lordship's permission, may I mention item 11? I know.
My lord, with
Just
liberty-
for my,
Late in the function
Now, your lordship said a farewell.
by Sora.
that's why, my lord,
My lord, with liberty, may I?
that's why I said I may go a little earlier, because I have to be there at the right time.
Yes, yes.
So you don't mind if I go a little earlier?
We don't want your presence.
No. I want to be here.
In any case, my lord, I am not reading anything outside the brief.
My lord, my lord, may I mention in item 50 today, my lord, because of work matter, it cannot be taken. May I request to taken up day after tomorrow, my lord.
What is it about?
My lord, it is because of it's a IA in Godavarman matter, my lord, where the state has closed the portal for mobilization of the raw material, my lord. We have our commitments to the clients, my lord, so we just want some order from my lord.
We'll have it on Monday.
All right.
We are having all TN Gozara matters in the next week.
All right, well, on Monday it's fine, my lord. We'll give the numbers, my lord.
Lordship, may I mention item 37, it was taken up, your lordship, were pleased to issue notice. Our lordship, there were two IAs, one is for permission to file and the other was for deletion of certain respondents. Our lordship, they were not they were parties before the lower courts. However, lordship, their addresses were not available. So lordship, that application has been moved. I'm only praying that those IAs may also be allowed.
No?
Lordship, one IA was for permission.
What do you want?
I want those IAs to be allowed, lordship. Your lordship's already been pleased to issue notice.
Who is your opponent? Who is your opponent?
Lordship, these are private respondents.
Who's your opponent?
So, lordship, this is a fresh matter. We'll list it only two.
Your lordship's permission, may I mention item 11. It is on your lordship's board today. Your lordship may have it next week. The urgency is next week.
After 2 weeks.
Millets, I'm mentioning in IA in the writ petition concerning Telangana Judicial Service Examination, Millets. In this, Millets, the petition results has been withheld by the respondents, Millets. They have declared results of these candidates belonging from Telangana and withheld the results candidates belonging from Andhra Pradesh, Millets. Millets, we are seeking for the permission to declare the results, Millets.
Is it listed today?
No, Millets, it's not listed, Millets.
This is not a matter of time for mentioning. You should mention it in the morning matters.
So I apologize, Millets.
Sorry, yes. Yes, Mr. Mehta.
Please, Your Lordship.
No, sir, एक minute. Sir, I have a SLP 4275. Sir, आप kindly 23rd और 30th में डेट देंगे सर. 20 में भी था सर, रीच नहीं कर रहा सर. प्लीज सर. SLP. सर, सर्विस मैटर आप थर्ड कोर्ट में भी.
देंगे, डेट देंगे आपको.
सर, प्लीज सर.
डेट देंगे ना आपको. उनको डेट देने की.
Thank you.
Lord, kindly, my lord, now I'll come to the next point. Lord, the point that why government property under encroachment is separately treated. Lord, I'll only cite 2 paragraphs of 2 judgments which are already part of my written submissions.
Through with this. You are on the 95 Act.
Yes, my lord, kindly, my lord. Yes, my lord, that is, I wanted to show, my lord, the registration, but kindly, my lord, come to page 61 of my
affidavit.
My affidavit, my lords. Lord, I was showing section 36, my lord. Page 44, my lord.
Page 44.
44 of my reply. Section 36 of the 95 Act. Lord, this is as enacted in 95. Your Lordship gets one.
Yes.
Every Wakf, whether created before or after commencement of this Act, shall be registered. So 23 continues, 54 continues, 94 continues. Then it is not necessary that only Mutawalli gets it registered. The Act is liberal. So far as registration is concerned, it is compulsory. There is a sanctity. But who can get it registered? Anyone can get it registered because the purpose is to incentivize registration so that such public denominations come under the regulatory framework. Please see subsection 3. No document required. Only details, description of work property sufficient to identify, etc., etc. Same. Then 7, Lord, again, you in subsection 4. Subsection 4. Every such application shall be accompanied by a copy of the Waqf deed, or if no such deed has been executed, or a copy thereof cannot be obtained, shall contain full particulars as far as they are known to the applicant of the origin. Lord, this false narrative which is created, that now we are being called upon to show documents, and otherwise the Waqfs are being snatched from us en masse. Therefore, what I am showing that virtually, my lord, the country is misled. Now, my lord, even my lord, this is omitted now. Now, 7. On receipt of an application for registration, the board may, before registration of the Waqf, make such inquiries as it thinks fit in respect of the genuineness and validity. When if it's a Waqf by user, my lord, somebody will have to examine whether in fact there is a user or not. If it is my property, I am using it as a Waqf, or I have dedicated as a Waqf, my lord, nobody, no question would arise. 8 gives yet another window that you may be a 100-year-old Waqf. If you have not registered yourself, I am giving you 6 more months from today. 95 Act says there is a window. Now, my lord, this is the reason why Waqf by user is not permitted henceforth after the amendment prospectively. 3 exceptions. 1, it should be registered. I have given, my lord, the reasons why registration is insisted upon. Your lordships will not have any mechanism if somebody gets up and says that there was a Waqf by user which was being used up to 2024. We couldn't get it registered. That is not an answer, because that would amount to legitimizing what has always been considered to be punitive since 102 years. Second exception, if it's a private property, it would be governed by the competent court's discretion, competent court's adjudication, and nobody can not find fault with them. No person can say that irrespective of the dispute, I will be the Waqf by user. If it is Waqf by user declared by the competent court, it will be Waqf by user. If it is not so declared, it will not be Waqf by user. And third is the government property, my lord, and for which I'll cite only 2 judgments, my lord. Please come to my written submissions, page 13 and 14. And not even, my lord, I am not going to cite judgments. I'm sorry, my lord, I wanted to show, my lord, my lord, 61. I wanted to show, my lord, what will be the effect of the stay. No, we are not arguing the matter for final hearing. Page 61.
Okay, I will read.
Yes, my lord. Para 101. It is submitted. I'm sorry. It is submitted that if the effect of the section saving only registered Waqf by user is interfered with either directly or indirectly by any interim order, it will not only defeat the object and provision of, it should be purpose itself, it will result in the following anomalies which the order of the court cannot lead to. It will amount to creation of a legislative regime by a judicial order, and that to an interim order wherein Parliament has by law consciously taken it away. It would defeat the object, intent and purpose of the Act in general and amendments in particular. This would give a premium to unregistered Waqf by user who have been defying law of the land since more than 100 years, though non-registration has always been penalized. It would legitimize something that is unregistered Waqf by user, which is precluded and penalized by law. It would be impossible for this court, or for that matter, any authority, to prevent anyone fictitiously claiming Waqf by user in 2025, though it has never been identified in the statutory process of Survey Commissioner, the process of Waqf Board, and each state a Waqf board of each state and has never chosen to apply for registration. Somebody may say that this has been we have been using this as a Waqf by user since 2024. All right, we didn't get it registered. Survey commissioner also could not find out. The board also did not find out. Lord, there is no mechanism, my lord, who will decide this. Therefore, my lord, there is a cutoff line. It would encourage the mischief which is reflected in the report of Waqf Inquiry Committee in the year 1976 quoted here in above, which categorically notes that some Waqfs are deliberately trying to avoid registration, concealing Waqf which affects the administration of the Waqf. So, my lord, therefore, your lordships may not consider, my lord, and I am repeating, my lord, I am respectfully arguing only for the purpose of opposing the interim order. Now, please come to para 13 of, my lord, my page 13 of my written submissions. I have quoted the relevant para. Why government should be interested, my lord, in protecting its property. Lord, government is not the owner of the property. Government is a custodian of the property for and on behalf of 140 crores Indians. My lord, only two. My lord, page 13 of my written submissions. My lord, this is state of Andhra Pradesh.
Short note.
Yes, my short. State of Andhra, page 13. My lord, here the state government filed a petition against the Waqf board. And the facts, my lord, we may not go into it, my lord, by Mr. Ranjit Kumar appeared in the matter. Lord, facts of the case are very glaring. Virtually, my lord, the government land was encroached upon, but I'm not going into it. My lord, para 39, I have quoted, my lord, state of AP versus AP Waqf board. Thus, the state government as a juristic entity has a right to protect its property through the reed court, just as any individual could have invoked the jurisdiction of the court. My lord, please turn the page over and come to the next judgment, my lord, Hanumaiya. Karnataka High Court, my lord, Supreme Court versus State of Karnataka. I'll read only the highlighted part at page 15, my lord. I'll not read the full. Government properties, your lordship gets, my lord. Page 15.
Hanumandaya.
Yeah, yes, Hanumaiya versus State of Karnataka.
Bolded part.
Bolded part, my lord. Government properties are spread over the entire state, and it is not always possible for the government to protect or safeguard its properties from encroachments. Many a time, its own officers who are expected to protect its properties and maintain proper records, either due to negligence or collusion, create entries in record to help private parties to lay claim of ownership or possession against the government. Any loss of government property is ultimately the loss to the community. Courts owe a duty to be vigilant to ensure that public property is not converted into a private property by unscrupulous elements. This is the mischief, my lord, which is sought to be remedied by providing for a mechanism that designated officer will be there. He will, my lord, I have said, follow the principles of natural justice, follow the procedure, and thereafter the decision would be taken only to change the revenue record. And that decision also will be amenable to judicial review. Now, my lord, another point, my lord, my learned friend argued that this amounts to the government acting as a judge in his own cause. My lord, first of all, it is always for the revenue authorities to decide the question of revenue entries, my lord. But similar question arose before your lordships, my lord, in case of a public premises eviction of unauthorized occupant sec, where the argument was that the government body appoints the estate officer and you are becoming a judge in your own cause. But please have a look at page 93.
Competent authority.
Yes, competent authority, my lord. Page 93 of my counter, my lord. Crawford Bailey versus Union of India. It's a Supreme Court judgment. Page 93, bottom. Your Lordship gets, my lord? I'll read the quoted part, the judgment. In this connection, a reference was made to Delhi versus so-and-so with regard to personal bias. That is, an officer on the statutory authority has been appointed as an estate officer. Therefore, they will carry their personal bias. However, this court in the aforesaid case held that the doctrine no man can be a judge in his own cause can be applied only to cases where the person concerned has a personal interest or has himself already done some act or taken a decision in the matter concerned. Merely because an officer of a corporation is named to be the authority does not by itself bring into operation the doctrine, no man can be a judge in his own cause. For the doctrine to come into play, it must be shown that the officer concerned has a personal bias or connection or a personal interest or has personally acted in the matter concerned and or has already taken a decision one way or the other which he may be interested in supporting. Because government will have to act through officers. Now, my lord, page 7 of my note. My lord, the contention which I am respectfully urging, my lord, for your lordship's consideration is Waqf by user is not a fundamental right. It was recognized by statute in 1954 and before also, my lord, Bengal Act, etc. My lord, the judgment says that if some right is conferred by the statute as a legislative measure, as a legislative policy, the right can always be taken away by the statute. That is the proposition for which, my lord, only one judgment, my lord, I will respectfully rely upon. That is at page 7 of my written submissions. Waqf by user was introduced in 1954 as a legislative policy, which is now taken away by the competent legislature in view of the change in legislative policy and in view of the mischief, my lord, which I have already demonstrated, which is sought to be curbed. Lord, your lordship, get para 52. Lord, this is 2009 8 SCC 46. A right which primarily flows from a statute cannot claim its constitutional pedigree to become a constitutional threshold against which constitutionality of a statute can be tested. But the court goes to this extent. It is tried that a right which may be conferred by a statute can also be taken away by another. It is also tried law that the state is entitled to change its legislative policy having regard to the ground realities and changing societal condition. In fact, the legislature is expected to take steps for enacting a new statute or amending the same so as to keep pace with the changing societal condition as well as taking into consideration the development of law, both domestic and international.
Not to create.
Yes, my lord. Now I come to, my lord, the second point, my lord, that is essentially based upon Article 25 and 26. My lord, my respectful submission is, my lord, and I was not aware, my lord, till I my lord, researched this doctrine of essential part of religion was evolved by Dr. Ambedkar. My lord, I subject to correction, I could not find any judgment, my lord, which attributes that, my lord, idea to Dr. Ambedkar, but there is, my lord, in my written submission, one paragraph. My lord, the submission is this, and I'll make that submission good. Waqf is an Islamic concept, no dispute about it. But Waqf is not an essential part of Islam. And unless and until, my lord, that is shown, the rest of the arguments would fail. And there is one or two judgments, my lord, direct judgments on the point which I'll show, which says that charity is a part of every religion. That happened, my lord, in case of a Christian religion. That Christianity, charity is a part of the religion. The Supreme Court says, no, it's not an essential part. Because Hindu also have a system of dan, Muslims have a system of waqf or any other form of charity. Sikh religion has every charity as a part, but it's not an essential part. My lord, kindly see first, my lord, Dr. Ambedkar's speech, my lord, in my written submission at page 42. This is where, my lord, he for the first time demarcated between religious practice and essential religious practice. My lord, the discussion was with regard to the Uniform Civil Code, but we are not concerned right now, my lord, with that. Please see, my lord, in the middle, the Honorable Doctor, page 42. The Lordship gets, my lord, the Chief Justice gets, my lord. Justice MASIH gets. Page 42, the Honorable Dr. B.R. Ambedkar. Coming to the question of saving personal law, I think this matter was very completely and very sufficiently discussed and debated at the time when we discussed one of the directive principles of this constitution, which enjoins the state to seek or to strive to bring about a uniform civil code. And I do not think it is necessary to make any further reference to it, but I should like to say that if such a saving clause was introduced into the constitution, it would disable the legislature in India from enacting any social measure whatsoever. Now, please mark this. The religious conceptions in this country are so vast that they cover every aspect of life from birth to death. There is nothing which is not religion. And if a personal law is to be saved, I'm sure about it that in social matters, we will come to a standstill. I do not think it is possible to accept a position of that sort. There is nothing extraordinary in saying that we ought to strive hereafter to limit the definition of religion in such a manner that we shall not extend beyond beliefs and such rituals as may be connected with ceremonials which are essentially religious. Essentially religious practices are saved and not all religious practices. My lord, now a direct, my lord, judgment which your lordships would find, my lord, in my, I have quoted, my lord, in my affidavit in reply, my lord, and therefore they had a notice, my lord. It is at page 101 of my counter. Page 101.
Of the counter?
Of my counter, my lords. That does your lordship. I'm sorry. Page 101, it is John Velametom versus Union of India. Yeah, Lord, my lord, may I read with my lord's permission? My lord, kindly see the bold part. I'm sorry, 101. Well, for the first time, my lord, in this, my lord, Dr. Ambedkar said that
that's why I was
religious practice and essential religious practice. My learned senior, my lord, wants me to read.
That's okay.
Your lordships have read further also. Mr. Ranjit Kumar says that further lines are also important. I stopped it. May I read, my lord, or?
to you.
I'll, my lord, just. Yes, my lord. I'll just, my lord, read. It is not necessary that the sort of laws, for instance, 42, page 42. It is not necessary, my lord, where I stop, I'll start from there. It is not necessary that the sort of laws, for instance, laws relating to tenancy or laws relating to succession should be governed by religion. In Europe, there is Christianity, But Christianity does not mean that Christians all over the world or in any part of Europe where they live shall have a uniform system of law of inheritance. No such thing exists. I personally do not understand why religion should be given this vast, expansive jurisdiction so as to cover the whole of life and to prevent the legislature from encroaching upon that field. After all, what are we having this liberty for? We are having this liberty in order to reform our social system, which is so full of iniquities, so full of inequalities, discrimination and other things which conflict with our fundamental rights. It is therefore quite impossible for anybody to conceive that a personal law shall be excluded from the jurisdiction of the state. Having said so, my lord, etc. Now, my lord, directly on the charity, and my lord, nobody can dispute the proposition that Waqf is a charity. It's a charity in Islam. What is Dan is Hinduism. What is charity in Christianity? Waqf is in Islam. Now kindly see, my lord, John Valamartham, page 101 of my written of my affidavit, my lords. A disposition, your lordship gets one of the bold highlighted part. A disposition towards making gift for charitable or religious purpose. I'm so sorry. Would your lordship like me to read from the beginning? I'm sorry.
This is in the amended 3B.
No.
You could see that. You know, Act says so. So just make a note of that. Okay.
So page 101, I'll read, my lord, only the bold part. Just to save time, my lord, I have quoted entire para. A disposition towards making gift for charitable or religious purpose may be a pious act of a person, but the same cannot be said to be an integral part of any religion. It is not the case of the petitioners that the religion of Christianity commands gift for charitable or religious purpose compulsory, or the same is regarded as such by the community following Christianity. The petitioner has not been able to place any material to show that disposition of property for religious and charitable purposes is an integral part of Christian religion faith. Now 41. Disposition of property for religious and charitable purpose is recommended in all religions, but the same cannot be said to be an integral part of it. If a person professing Christian religion does not show any inclination of disposition towards charitable or religious purposes, he does not cease to be a Christian. Even certain practices adopted by the persons professing a particular religion may not have anything to do with the religion itself. But I'm posing a question to myself. Suppose majority of the Muslims, my lord, which are not financially sound, if they do not create a waqf, would they cease to be Muslims? That's the test, my lord, Supreme Court has laid down. There are countries, my lord, where there is no concept of a waqf. You have to register as a trust. Charity is a part of every religion, but not an essential part of any religion. And therefore, waqf per se is not an essential religious practice.
Education, religion, and any other purpose.
Yes. So now, my lord, I'll come to section 9 and 14, that maximum two members are, my lord, provided for. My lordships have seen yesterday, there are 3 layers. Lord, I must make this very clear. The top layer, I'm using it broadly, is Waqf Council. It's an all India level body having jurisdiction of supervisory advisory nature. It advises the central government. It issues directions to boards, state boards. Regarding what? Regarding administration of the Waqf boards. It does not deal with Waqf. Waqf means a mosque or a hospital or a school or anything. Second layer is the Waqf board. The Waqf board again discharges only secular functions. Secular function means Waqf board in every state would see that if there are 100 Waqfs, they are properly maintained, their register is maintained. If there is a succession of managing committee members, that succession takes place, that accounting is proper, their accounts are audited, etc., etc. My lord, I have, my lord, therefore, I will not read, my lord, the entire provision, but please see, my lord, the functions of the Waqf board, my lord. It's purely secular and I am on that 2 maximum members. My lord, please come to page 48 of my written submissions. My lord, the Chief Justice may kindly have a look at page 48. Lord, I am showing this to show that having maximum 2 Muslim members, would it change any character? Waqf is, my lord, Waqf board is not touching upon religious activity of any Waqf, as against, my lord, Hindu Endowments Act. My lord, I'll show, I'll just give examples. In, my lord, Hindu endowments, the Hindu Endowment Commissioner can go inside the temple. The pujaris are appointed by the state government. He decides what money is to be spent on dictum. Dictum means dhoop, batti, my lord, other puja items, etc. They appoint, my lord, pujaris. Here, this is the function of the Waqf board. They do not touch upon any religious activity of any of the Waqf. And this is the distinction, my lord, between Waqf and any other religious institution. Please have a look at, my lord, my Chief Justice, my lord, may kindly have a look at page 48.
Oh my God.
My lord, please see page 48. Record keeping functions. I have given the sections, my lord, on the side. I'll not read. I need not read, my lord. We are at an stage whether your lordship would like to stay this microscopic minority of 2 non-Muslims being appointed. Then litigation related functions, financial regulatory functions, general regulatory functions. I have given the sections. And then property management functions. It's a supervisory body. It exercises the power of superintendence regarding the secular activities. Now at
Decision property is not property with the board.
Lord, now repeatedly, without referring to the article, reference was made to Article 25 and 26. Lord, only for a second come to Article 25 and 26, and then I'll take your lordships to those 2 members. We are dealing with, my lord, a body, namely Waqf Council and Waqf Board at the state level, Waqf Council at the center, Waqf Board at the state level, which merely undertake secular functions supervision. And Constitution permits that. Lord, please come to 25 first. This was not shown, my lord. 25, Article 25. We are concerned with 2A. The Wakf Act is traceable to Article 25 2A. Your Lordship gets, my lord, Article 25. 25, nothing in this article shall affect the operation of any existing law or prevent the state from making any law, A, regulating or restricting any economic, financial, political, or other secular activities which may be associated with religious practice. My lord, there is a power of regulating secular practices relating to religion. Now please come to 26. Freedom to manage religious affairs. Subject to public order, morality and health, every religious denomination or any section thereof shall have the right, kindly come to D, to administer such property in accordance with law. So administration of property will have to be in accordance with law. In other words, the competent legislature has the competence to enact the law with regard to administration of such property without touching upon the religious part of it. My lord, having shown this, please come to, my lord, this 4 members and 2 members, my lord, maximum. My lord, please come to, my lord, I'm sorry, my lord, I'm requesting your lordships to shuffle through affidavit and written submissions. Please take my affidavit, my lord. And this is a part of my affidavit, part of the JPC report. The Ministry of Minority Affairs has placed on record before JPC, and still your lordships were told for more than half an hour that there can be maximum 11 or 12 non-Muslims and there would be Muslims in minority. Well, this is unfair. JPC has recorded all this and I have placed the JPC report on record and I have quoted it in my affidavit in reply so that you don't have to go through that 1500 pages report. Please come to page 73. Well, I am not reading the section 9 again. We are concerned with that proviso. 2 members. 9 and 14 both have the proviso. And both, my lord, I have quoted. Page 73, para 119. Your lordship gets, my lord. It is further submitted that the relevant ministry has unequivocally stated the following before the Joint Parliamentary Committee with regard to the interpretation of the proviso concerning non-Muslim members in the council and the boards. My lord, kindly see the quoted highlighted part. This is ministry's answer to the JPC in writing. The changes introduced in the constitution of the Central Wakf Council are designed to create 2 categories, one category exclusively for Muslims, 10 members, and another category, 12 members. This is exclusive. Out of this second category, 2 members will be non-Muslims. Remaining all will be Muslims. This is in writing given to JPC, which is placed before the parliament, which is forming part of my counter, and tomorrow, yesterday, half an hour was, my lord, argued that this can be maximum anything. That majority would be majority would be non-Muslim. Please see further, my lord. Thereafter, my lord, my lord, kindly see, my lord, the observations and recommendations of the committee at page 74, para 11.7. The committee, after thorough, your lordship gets, my lord, the Chief Justice gets, Justice MASIH gets, my lord, page 74. My lord, this is the part of the JPC. The committee, after thorough deliberation upon the proposals made in the clause under examination, including the views, suggestions of the stakeholders and justification given by the Ministry of Minority Affairs, find that composition of the State Wakf Board has been expanded to include 2 non-Muslim members and ensure broader representation from Shia, Sunni and backward Muslim communities. My lord, earlier it was Shia and Sunnis. Now, my lord, now Aga Khani and Dawoodi Bohras are also added. Shia, Sunni and backward Muslim.
Is there any specification to that effect?
Yes, yes.
In the
book, yes. Which will promote inclusivity and diversity in Waqf property management. The committee feels that non-Muslims can be beneficiaries. Kindly see, this is the logic why there are two non-Muslims. Non-Muslims can be beneficiaries, can be parties to the dispute, or otherwise interested in Waqf matters which justify their inclusion in the administration of the Waqf. Now, please see, my lord, 120. This is the, again, Ministry of Minority Affairs saying on affidavit before your lordships, and the affidavit is given long back to them. It is submitted that the changes in the composition of the Central Waqf Council, which is on next para, my lord, page 75, para 120. 120, my lord, your lordship gets. It is submitted that changes in the composition of the Central Waqf Council, which is only an advisory body, and the Waqf Board, which only supervises secular activities, do not impair the Muslim community's right under Article 26. The following aspects may be noted. In case of Central Waqf Council consisting of total 22 members, maximum 4 members can be non-Muslims. The minister, the ex officio joint secretary, and maximum 2 members. If the ex officio chairman, that is minister concerned, and the joint secretary of the government, who is also ex officio, are Muslims, then only 2 members can be non-Muslims. There is a possibility, my lord, in every state.
Normally in the states, the
minister is always usually Muslim. Yes, my lord. Even JS can be Muslim, my lord, then maximum 2 out of 22. In case of Waqf Board, my lord, B, consisting of total 11 members, maximum of 3 members can be non-Muslims. If the ex officio joint secretary is a Muslim, then only 2 members can be non-Muslim. Thus, it is clear that non-Muslim members are in a microscopic minority, and they are included to give inclusivity and with a view to ensure their participation. Since the secular aspects of Waqf administration may require dealing with issues concerning non-Muslims who are either beneficiaries, aggrieved parties, or affected parties, they are there. Lord, there are, Lord, Waqf does, this is the basic distinction between Hindu religion endowments and, Lord, Waqf. Hindu religious endowments are only religious, while Waqf can be anything. It can be a mosque or dargah or something, or it also can be a school, it can be a college, it can be a musafir khana, it can be an orphanage. There are several secular charitable institutions which are being run. And therefore, my lord, there can be a law which provides for a minority participation of other than Muslims, since the Waqf Board deals with non-Muslims also. Lord, another thing, Lord, kindly appreciate. Lord, in Bombay and in Gujarat, we have Bombay Public Charitable Trust Act.
Public Trust Act.
Bombay Public Trust Act. Gujarat, we have Gujarat Public Trust Act.
1950.
1950. Now, my lord, all temples are governed by Bombay Public Trust Act. Suppose the charity commissioner is a Muslim, can be a Muslim.
In Maharashtra, there have been.
In fact, as a matter of fact, Waqfs were being governed by the charity commissioners for some time. That is what, my lord, I have pointed out in my affidavit, my lord. Please have a look at page 80, page 79. So temples which are purely religious, unlike, my lord, Waqf, which can be other charitable also, can be, my lord, under the administrative supervision of a non-Hindu.
But under the Bombay Public Trust Act, only religious institutions do not come.
No, everything,
all
public trust, but including religious Hindu public trust also. Hindu Jain religious trust also. They would be governed by that. There is no state, no, there are 4 or 5 states where there are religious endowments. Rest, my lord, like Bombay, like Gujarat, like Madhya Pradesh, like Rajasthan, all Hindu temples, Jain temples, etc. are governed by the respective public charitable secular law. And the charity commissioner, my lord, is the supervisory authority. He can be a non-Hindu, he can be a non-Jain, he can be anyone, my lord. Now, please see, my lord, this is something peculiar to Maharashtra, page 79, para H. Even Waqfs used to be under administration, supervision, and control of non-Muslim charity commissioners in many states. It is respectfully submitted that the Wakf Act was not made applicable to the state of Maharashtra till coming into force of Wakf Act 1995, that is 1196. In other words, prior to 1196, Muslim trusts and Waqfs, except those in the region which were governed by Wakf Act of 1954, were covered and governed by Bombay Trust Act, it should be Public Trust Act 1950, and were managed, administered and supervised by the Charity Commissioner of Maharashtra, who may or may not be a Muslim. Now, my lord, I am not going into the further details of it, my lord, because the question is, my lord, I am posing a question to myself, would this be a case for stay? Lord, if there are appointments of 2 Muslim members, Lord, no prejudice is going to be caused, and ultimately, if your lordship sets aside this, my lord, on the on any ground, they would cease to function. Staying this provision would amount to allowing the petition without any adjudication. My lord, another thing, my lord, there is a vital difference in case of Waqf, my lord, and I'm taking example of religious Waqf, Dargah or mosque. My lord, there are 2. My lord, Bombay Public Trust Act, the definition, Maharashtra Public Trust Act, the definition of public trust means an express or constructive trust for either a public, religious or a charitable purpose or both, and includes, please mark this, a mutt, a temple, a mutt, a waqf, church, synagogue, agyari or other place of public religious worship, a dharmada or any other religious or charitable endowment, and a society formed either for a religious or charitable purpose or for both, etc., etc. The Charity Commissioner deals with all religious institutions. Now, my lord, kindly see, in case of a Waqf, which is religious in nature, there are 2 categories. My lord. There are 2 offices which, my lord, we are concerned with. One is called Sajda Nashin. Sajda Nashin is the spiritual or religious head of that Waqf. And second is Mutawalli. Mutawalli is an administrator of the Waqf. It's kind of a manager. None of the provisions of the Act directly deals with Sajda Nashin, because he is the person who does the religious function. My lord, only in one place the Act uses the word Sajda Nashin in the definition of Mutawalli, where it says that in a given case, Sajda Nashin can be...
My lord, it's Sajjada Nashi, not Sajda.
Is Imam.
That's
I'm sorry, it is Sajda Nashin.
Sajjada Nashi.
You are spelling it wrong.
And it is his Imam.
You are pronouncing it wrong. Sajda means to bow before the God.
Imam.
That is Sajda. To touch your head, my lord, then you are pronouncing it wrong. It is Sajda Nashin. But be that, Sajjada Nashin. If they want Sajjada Nashin, I have no difficulty.
Imam of
the real pronunciation in my understanding is Sajda. It's called Sajda.
Imam
I leave it. Why are you interfering? Let it finish. It's answer when they have.
Correct.
Sajda, my lord, has a meaning in Urdu on the lighter side. Sajda has a meaning in Urdu. It's except in, I'm not going into that intricacies, but Mutawalli, when it is defined, says that Mutawalli can delegate his powers to Sajjada Nashin. I bow down to them. I do sajda to them. Lord, I'm not reading it, page 110 of my written submissions. I have given judgments after judgments of the Supreme Court that Sajjada Nashin is religious head and Mutawalli is administrator. Wakf Act deals only with Mutawalli, who is a manager of the
100.
Page 110. Please have a look at, my lord. Only just have a glance. Oh, only one judgment is, all are, my lord, Supreme Court judgments. Please have a look. First, second, third, fourth, my lord, these are all Supreme Court judgments. Sajjada Nashin is a spiritual office. Mutawalli is a manager of secular properties. My lord, this is, my lord, judgment of the Supreme Court 2008, 8 SCC, page 12.
Where are you reading?
My lord, page 110.
Where?
Of my written submissions, I'm sorry.
110 where?
Bottom, at the foot. My lord, Fakhruddin versus Tajuddin. It's 2008, volume 8, SCC, page 12.
Correct. 110 of submissions.
Page 110 of the submission. My lord, kindly have both, my lord, to kind. My apologies, my lord, I am required to shift, my lord, from one to the other.
You are not permitting us to concentrate.
My apologies, my lord, to your lordship, sir. But I can assure your lordship, it's not deliberate, my lord. It's maybe
It's only on the lighter side.
I understand. I go.
110.
Yes.
So at least in English, what you are saying is correct.
My lord, it is sajda. I mean, sajda
In-
has a. See, my lord, I'm not going into it.
English spell is Sajjada Nashin.
Sajjada Nashin.
Not sajda, but anyway, that's
Anyway, my lord, sajjad. I don't join issue on that.
a much more serious issue than that.
Sajjada Nashin is a spiritual office. Mutawalli is a manager of secular properties. The Waqf board deals only with Mutawalli. Then, my lord, next judgment, and the next para 36. It is beyond any doubt or dispute that a Mutawalli is a temporal head. He is, I'm sorry.
Now again, back to.
No, same. Same, next para.
Yes.
Para 36 of the same judgment. It is beyond any doubt or dispute that a Mutawalli is the temporal head. He is the manager of the property. Office of Sajjada Nashin, however, is a spiritual office, which is not touched, my lord, under the Wakf Act or by the Wakf board in which there are two non-Muslims. Revenue authorities of the state are concerned with revenue. Mutation takes place only for so-and-so. Please see the bold part. Rules laying down a rule of primogeniture will have no application in relation to office of Sajjada Nashin and Mutawalli, which are offices of different nature. My lord, second judgment is Sayyid Saleh Hussain. My lord, same, my lord, law. There are two important offices in the shrine, Sajjada Nashin, the spiritual head, and the Mutawalli, the secular head. My lord, it goes on and on and on. My lord, I have whatever judgment we could find, my lord, we have placed for lordship's consideration, but we'll argue this, my lord, at the time of final hearing. This is just to show that the act does not deal with any religious aspect, essential religious practice of Islam.
Dedication itself is essential. The moment you think it's going to decide it. You're saying it in preferring. That's right.
And the power to appoint Mutawalli is with the board.
No, with the Wakf. The concern Waqif or Wakf. Mutawalli only, my lord, power, the board is only supervisory. Mutawalli is an administrator appointed by the Wakf concern. My lord, it is at the state level, there is a board. Correct? Look, kindly see that.
If the Mutawalli is be appointed by the Waqf.
By Waqf, but please see the definition.
Then what is the grievance?
Lord, they say that by two members in the Waqf board and Waqf council at the center, it interferes with our religious affairs. And my case is that board only supervises Mutawalli and his secular functions. Please, my lord, have a look at the definition of the word Mutawalli. Therefore, I am also surprised what's the problem. Except that you cannot have non-Muslims.
Mutawalli would be a Muslim.
May or may, it depends upon the Waqf.
The board has no
role.
No role to.
No role. My lord, kindly, my lord, for my satisfaction, have the definition of the word Mutawalli.
Under the 95 Act.
Under the 95 Act. My lord, this is the 95 Act. Amendment changed the name on it. It continues to be 95 Act. It now is Unified Waqf Management, Empowerment, Efficiency and Development.
Yes, Mutawalli. Aye.
Mutawalli. Mutawalli means any person appointed under any deed or instrument by which a Waqf has been created or by a competent authority to be a Mutawalli of a Waqf and includes any person who is a Mutawalli of a Waqf by virtue of any custom or who is a Nayab Mutawalli, Khandim, Munjawar, Sajjada Nashin, Amin or other person appointed by Mutawalli to perform the duties of a Mutawalli. So Sajjada Nashin can be delegated with the powers. Now, my lord, please see.
Sajjada Nashin can also be a Mutawalli.
If delegated with the powers, yes.
Or a Munjawar can also be a Mutawalli.
Yeah, yes.
One person can hold both the offices.
Munjawar is, my lord, I know it for sure, is a religious person. He is like a pujari. Munjawar is usually, my lord, in dargahs. But Sajjada Nashin will be performing duties of Mutawalli, not his religious duties. Please have a look at. Appointed by a Mutawalli to perform duties of a Mutawalli. But in any case, my lord, it is a board of 12 members, out of which 2 are non-Muslims. They do not do anything, my lord, with the Waqf. Waqf runs, except, my lord, what I have shown, the functions of the board. My lord, kindly, my lord, again, for my satisfaction, have a look at, my lord, the functions of the board. Lord, there is a separate, my lord, chart which I have shown, my lord. In this context, page 48, my lord, please have a look at 48 of my written submissions. This is all Waqf does, my lord. This is the Waqf having 2 non-Muslims out of 12 does. I'm posing a question to myself, how does that affect their right under 25 or 26? Please have a look, my lord. Record keeping functions, examine and publish list of Awqaf, maintain record of origin, income, objects and beneficiaries, register of Waqf, issue registration certificate, maintain register of Waqf with detailed particulars, direct registration or amendment of Waqf records, etc. Then, my lord, litigation related functions, then financial regulations, audit, account, etc., etc. General regulatory functions. My lord, I have given section wise the entire scheme of the Act, my lord. There is only one, my lord, power which deals with Mutawalli, which is the removal of Mutawalli if he is guilty of misconduct. That is section 64. And misconduct is not, my lord, at the discretion of the board. In any case, my lord, board has pervasive Muslim presence, except to all are Muslims. But, my lord, misconduct under section 64 is a defined term, my lord. It is, he has been convicted, if he has been unsound mind, undischarged, insolvent, proved to be addicted to liquor, etc., etc., etc. Then board can remove him, except that there is no interference. Yes. And 63, my lord, is an exception, power to appoint Mutawalli in certain cases when there is a vacancy in the office of Mutawalli of a Waqf and there is no one to be appointed under the terms of the deed of work, or where the right of any person to act as mutawali is disputed, the board may appoint any person to act as mutawali for such a period. It's a temporary, my lord, appointment being made if there is nobody to handle. But again, mutawali, who is an administrator, who is a manager, who has nothing to do with the religious affairs. But I will show, my lord, some of the judgments. An argument was raised that a pujari, that is Archaka, my lord, under the Tamil Nadu Act, who goes inside, my lord, the Garbhagriha, sanctum sanctorum, who performs everything, my lord, snan, abhishekam, changing, my lord, clothes, etc. of the deity, is appointed by the state government. This was objected on the ground of 25, 26, and court says, no, it is a secular function. And we are arguing that two microscopic minority non-Muslims in a Waqf board, because Waqf board deals with several other non-Muslims, would affect Article 25 and 26. Lord, this comparison is in principle objectionable. That why not for Hindus, why not for Muslims, why not for Christians? And this court has deprecated that. This court has deprecated that. I'll tell your lordships why. I didn't want to, my lord, make this argument, but for the argument being raised on the basis of this comparison. My lord, when Hindu Code Bill came in 1956, the personal rights were taken away for marriage, for inheritance, for divorce, for Hindus, for Christians, for Sikhs, for Jains, for Buddhists. No argument was raised that why not Muslims? Muslims are governed by their personal law because of Sharia Application Act. This is what, my lord, pity. This is what, my lord, on such comparison, this honorable court says. But I'll just read it, my lord. It's a part of my compilation. I don't want your lordships to lift this heavy compilation, my lord. It is Pannalal Pitti versus State of Andhra Pradesh, my lord. And the citation is 1996, volume 2 SCC 498. It says comparison is not possible. Supreme Court says, my lord. Well, I'll just read. Your lordship need not open, my lord. The first question is whether it is necessary that legislature should make law uniformly applicable to all religious or charitable or public institutions and endowments established or maintained by people professing all religions. In a pluralist society like India, in which people have faith in their respective religions, beliefs or tenets propounded by different religions or their offshoots, the founding fathers, while making the constitution, were confronted with problems to unify and integrate people of India professing different religious faiths, born in different castes, sects, or subsections in the society, speaking different languages and dialects in different religions, and provided a secular constitution to integrate all sections of the society as a united Bharat. The directive principles of the constitution themselves visualized diversity and attempted to foster uniformity amongst people of different faiths. A uniform law, though is highly desirable, enactment thereof in one go perhaps may be counterproductive to unity and integrity of the nation. In a democracy governed by rule of law, gradual progressive change and order should be brought about. Making law or amendment to a law is a slow process, and the legislature attempts to remedy where the need is felt most acute. It would therefore be inexpedient and incorrect to think, etc., etc. You cannot compare. Why not Hindus? I'll tell you, lordships, why not Hindus?
This paragraph?
12. Para 12.
Pannalal?
Pitti. Pannalal, Bansilal, P-I-T-T-I, Pitti. Lord, it is 1996. Sorry, 1996 to SCC.
96 or 86? 96. 1996.
1996.
498.
Yes, Lord, 2 SCC 498. Pannalal. Lord, it is at page 35 of my written submissions. My lord, why there cannot be any comparison between Hindu Religious Endowments Act and Waqf, my lord? I have, at the cost of repetition, Hindu Religion Endowments Act deals with only religious activities, while Waqf has many other charitable activities. Second, those acts directly deal with temples and not, my lord, unlike board doesn't deal with Waqfs, their religious activities. Here in Hindu Endowments Act, the control is too pervasive. My lord, sometimes, my lord, we feel that it is unacceptably pervasive. My lord, there are challenges pending against those Religious Endowments Act. Hindu Religious Endowments Act are under serious challenge. My lord, please see, my lord, what is treated to be secular in the context of Hindus. My lord, please have a look at page 45 of my written submissions. Your lordships would be surprised. I'm sorry, 31, my lord, of my written submissions. Page 31 of my written submissions. My lord, this is why Hindu endowments cannot be treated, because the judgments are that even inside the temple, my lord, the endowments authorities go. My lord, their argument is that Hindu Endowment Commissioner has to be practicing Hindu. Why? Because these are the activities they do. Please have a look at, my lord. And these are, my lord, the functions Supreme Court of India has stated to be secular. Setting standards of expenditure for dittam. My lord, dittam would mean Dhup, Deep, Naivedyam, used for puja, ceremonies, etc. The commissioner decides. To be fixed by the commissioner. Supreme Court says this is a secular activity. Government of Tamil Nadu, my lord, that's Hindu Religious Endowments Act. Power to frame scheme by commissioner appointed by the government. My lord, please see at the bottom. My lord, I don't wish to, my lord, go into it. My lord, there were sacrifice of cow, etc. is not held to be essential religious practice, my lord. But, my lord, please have a look at, my lord, Dargah Committee judgment, my lord, at page 32. My lord, there was a practice that whatever offering comes, my lord, in Dargah Committee, my lord, that is Khwaja Moinuddin Chishti, my lord, in Ajmer, used to be taken by one set of people. By act, that was deleted. Supreme Court says that long practice also can be deleted by the statute, by the legislature. Then Tilkayat, my lord, that is this Srinathji temple. My lord, here, long, my lord, kindly come to page 32, my lord, so that I don't have to read judgments, my lord. For that, I have my lord, very crisp chart, my lord, I'm giving. And thereafter, I'm immediately coming to the next point. There is a provision, my lord, according to me, a shocking provision, where Mahant of a Math, undoubtedly, undisputably, a religious head, the state government appointed board can remove that Mahant on the ground that he is not discharging his religious functions properly. I'll show that provision. And that provision is upheld.
On the ground that it is connected with the secular functions of the.
I'll show the provision, which is that 152. 152. Section 152. Please have a look, my lord. It's really, my lord. Anyway, my lord,
We are not considering challenge.
137.
In any way, we are not considering challenge to it.
No, my lord. 137, my lord, your lordship will examine this, my lord, in a combination of a larger bench, my lord, one day. Please come, my lord, to 137 first.
137 of counter.
No, my lord, I'm sorry, my lord. Written submissions.
You need to say that along with that.
Written submissions. I'm sorry, my lord.
You should now start saying either C or W.
Yes, yes.
That would get.
My lords are right. No, not counter, my lord. It is written submissions.
Annexure G.
Yes. Well, your lordship gets, my lord, it is removal of Mathadipati. Page 137 of written submissions.
137.
137, my lord, pagination is at the bottom.
Removal of Mathadipati.
Yes. Removal of Mathadipati. The Dharmika Parishad, and I'll show who is Dharmika Parishad. Dharmika Parishad may suo moto or on an application of two or more persons having interest initiate proceedings for removing a Mathadipati or a trustee of a specific endowment attached to a mutt. Lord, rest I can still understand, though Mathadipati cannot be touched, my lord. But kindly come to G. If he violates any of the restrictions imposed or practices enjoined by the custom, usage, or tenets of the mutt in relation to his personal conduct, such as celibacy, renunciation, and the like, leads an immoral life. And please turn the page, my lord. What is this? Dharmika Parishad, my lord, section 152. And these people sit together and decide to remove a Mathadipati of a mutt. They enter into a particular named religious institution. Please see 152. The government shall, by your lordship has, my lord, page 138. Next page. The government shall, by notification in the Andhra Pradesh Gazette, constitute Andhra Pradesh Dharmik Parishad for the state consisting of the following members: Minister for Endowment, who shall be the chairman, Principal Secretary, Secretary to Government Revenue Department in charge, the Commissioner of Endowment, the Executive Officer Tirumala Tirupati Devsthanam, one representative each from Chairman of Board of Trustees from so-and-so, so-and-so, a retired senior officer of the Endowment Department, retired judge of the High Court who is a devout Hindu and has, this is the compulsory Hindu, my lord. A legal luminary, he should be a Hindu. But otherwise, minister, officers, etc., they decide to remove a Mathadipati. My lord, only one judgment, my lord, I am tempted to cite before your lordship, my lord. My lord, page 34 of written submissions, my lord. Not that. Oh, Nani Balki wala. No, not, my lord. I'll read, my lord, one paragraph from my counter. My lord, allow me to show my counter. My lord, I said Archaka, my lord, and therefore, my lord, I am little. Mr. Palkiwala, my lord, argued this case and unfortunately lost, my lord, but look at his arguments. Please come to page 115 of my counter. Lord, Tamil Nadu government has this power. And we are arguing whether a microscopic minority being present in a board which deals with only administrative issues will violate fundamental rights. 115, your lordship gets, my lord? Lord, this is the judgment in Seshamal and others versus State of Tamil Nadu. Well, it's a constitution bench judgment, unanimous view. Please see, my lord, para 20. Mr. Palkiwala, your lordship gets, my lord, the Chief Justice gets. My Lord Justice Masih gets. Mr. Palkiwala, on behalf of petitioners, insisted that the appointment of a person to a religious office in accordance with hereditary principle is itself a religious usage and amounted to a vital religious practice and hence falls within Article 25 and 26. In his submission, priests who are to perform religious ceremonies may be chosen by a temple on such basis as the temple chooses to adopt. It may be election, selection, competition, nomination, or hereditary succession. He therefore contended that any law which interferes with the aforesaid basis of appointment would violate religious freedom guaranteed by Article 25 and 26 of the Constitution. In his submission, the right to select a priest has an immediate bearing on religious practice and the right of denomination to manage its own affairs in matters of religion. The priest is more important than the ritual, and nothing could be more vital than choosing the priest. Under the pretext of social reform, he contended, the state cannot reform a religion out of existence, and if any denomination has accepted the hereditary principle for choosing its priest, that would be religious practice vital to the religious faith and cannot be changed on the ground that it leads to social reform. Mere substitution of one method of appointment of a priest by another was, in his submission, no social reform. It is true that a priest or an archaka, when appointed, has to perform some religious functions. But the question is whether the appointment of a priest is by itself secular function or a religious practice. Mr. Palkhiwala gave the illustration of the spiritual head of a mutt belonging to a denomination of a Hindu sect like Shankaracharya, and expressed horror at the idea that such a spiritual head could be chosen by a method recommended by the state, though in conflict with the usage and the tradition of the particular institution. Where, for example, a successor or of a Mathadipati is chosen by Mathadipati by giving him mantra diksha, or where the Mathadipati is chosen by his immediate disciples, it would be, he contended, extraordinary for the state to interfere and direct that some other mode of appointment should be followed on the ground of social reform. Indeed, this may strike one as an intrusion into the matter of religion. Now the court says, but we are afraid such an illustration is inept when we are considering the appointment of archaka of a temple. Archaka has never been regarded as a spiritual head of any institute. They are pujaris. They are not spiritual head, but they are pujaris. They go inside the sanctum sanctorum. And now see, my lord, the bold part. That being the position of an archaka, the act of his appointment by the trustee is essentially secular. He owes his appointment to a secular authority. Any lay founder of a temple may appoint the archaka. The Shebayats and managers of the temples exercise essentially a secular function in choosing and appointing the archaka. The son of archaka or the son's son has been continued in the office from generation to generation, does not make any difference to the principle of appointment, and no such hereditary archaka can claim. But Lord, hereditary usual custom was done away with by the statute, and which is accepted. Right of Waqf by usurer is also, my lord, this will fall within this category. And my lord, we are arguing that why not?
In Maharashtra also, in Pandharpur.
Yes.
Earlier, they were all hereditary, they called it Badwas. Now by statute, it's done away with, and it's the government who can appoint.
Yes, my lord, but there is no narrative built. One and two. I'll read only one or two paragraphs, my lord. Volumes may be taken out first.
2 pages have to be. Counter affidavit, volume 2.
You want volume 1 and volume 2?
2. My lord, there are in few paragraphs from every.
Shares belong to the JPC, including the JPC report, the Act 23 Act 54.
Anyway, my lord, I'll just show. My lord, first see 3D. This was under challenge, my lord.
3D of the?
3D of the amended provision.
Of the Wakf Act.
This was challenge. My lord, this was not to be argued. I repeatedly say, but I am not, my lord, running away. I'll my lord, deal with it. But my affidavit says that my affidavit is confined to 3 points. That is Waqf by usurer, the government property, 3C, and my lord, 2 members. I've said in specific terms. But anyway, my lord, 3D.
According to them, 3D and 3A they were placed before the JPC and
of course it was placed. My learned friend said it was never before the committee, before JPC. Mr. Sibbal made that submission. The 3D was never before the committee.
3D and 3E also.
Yes, my lord, please have a look. I'll show, my lord.
The bill, I'm sorry, that it was not circulated.
No,
in the
now you
bill.
can't change.
No, I said that. Your lordships will remember that it's not circulated.
Lord,
in
I
the bill.
in fact got up and said that
That's
the
what I
record of the
exactly
submission.
said. It was not circulated in the bill.
No, you have said that it was not placed before the JPC also. And
Yes,
it was not part of the
I
original.
immediately
It
got
was
up
not
and
placed,
said that
it was
please
discussed,
record this
but not
submission.
placed, but not circulated in the bill. And the amendment was brought and I showed your lordship that amendment. So let's be clear on what I said. There is a paragraph in the JPC, but it was not.
Anyway,
in
my
the
lord,
bill
most
at all.
of the things which I argued from the record was not.
Fortunately, we'll
See report ended.
we'll say, we'll repeat what we had said. Section 3D and Section 3 was not circulated in the original bill.
Yes.
No discussion. No discussion, no time for discussion,
Yeah.
either in JPC or in Parliament.
Correct, because 3D,
yes,
there was no time for discussion and it was in the bill that was.
Anyway, let him answer.
Okay, my lord, I show from the JPC report. So please see, my lord, 3D. Please see, my lord, 3D. Your lordship gets, my lord, 3D. I'll read, my lord, slowly.
Why did they not circulate it?
Anyway, my lord, he did.
This is the thing as reported by JPC, to see the first one.
My lord, as a matter of fact, 3D is.
Therefore, I am recording. Normally,
I'm not going into, I'm not going into it. 3D, in fact, was suggested by JPC. I'll show it, my lord, that's what I want. My lord, please see 3D. Any declaration, the lordship gets, or notification issued under this act, or under any provision, any previous act, in respect of Wakf property shall be void if such property was a protected monument or protected area under the Ancient Monuments Preservation Act 1904 and the Ancient Monuments and Archaeological Sites and Remains Act 1958 at the time of such declaration or notification. If there is already an ancient monument declaration and if you declare that to be a Wakf, then that Wakf would be void. And what is the reason behind it? Please come to page 245 of the JPC. My lord, I have just prepared a note. My lord, this was, my lord, and I have not, my lord, made any submissions. This is only, my lord, the provisions are quoted. Because this was not to be argued and was argued, therefore.
Repeating the same thing, how many times would you repeat it?
Yes, as many times you repeated the.
We'll rather go to your note.
Lot of repetition.
Yes. Now, my lord, there are two words used, protected monuments and protected area. Correct, my lords? Please have a look at page 2. Protected area means any archaeological site and remains which is declared to be of national importance by or under this act. This has to be protected. It's a pride of the nation. Then protected monument means an ancient monument which is declared to be of national importance by or under this act. Correct, my lord? Then, my lords, may kindly see, archaeological site and remains means any area which contains or is reasonably believed to contain ruins or relics of historical or archaeological importance which have been in existence for not less than 100 years and include so-and-so, so-and-so, please. You can please, Mr. Brief in the evening, please. Continuously you did that when even Mr. Sibal was admin. This is what happened, my lord. He did say.
You proceed with.
Proceed. Don't.
Anyway, my lord. Now, my lord, kindly see what happens, my lord, with this. When it is a, my lord, a religious place and ancient monument both, the question was, and the statement, bold assertion was, we will be stopped from using it as a religious place. Your lordships would recall that. Answer is
I gave an instance about Khajuraho.
Yes, my lords gave an is kindly, it comes from section 5, subsection 6 of the Ancient Monuments Act. Please have a look at, my lord, page 3, I have quoted section 5. Nothing in this section shall affect the use of any protected monument for customary religious observances. Then 16 of this Ancient Monument Act, protection of place of worship from misuse, pollution or desecration. Please see subsection 1. A protected monument maintained by the central government under this act, which is a place of worship or shrine, shall not be used for any purpose inconsistent with its character. If it is a religious structure, it will be used for religious purposes. And my lord, why this was introduced in the JPC? You can not.
No, I just wanted to.
You have to leave. We are supposed to, starting at 4:30.
I have to be there earlier, but they're watching.
No, yes, but you told us we'll start at 4:30.
Yes.
My lord, please see the.
What he's quoting, I cited myself to your lordships.
No, I'm sorry. Your lordships would recollect, it's not less than 24 hours.
I cited it.
Yes. I'm reading it.
No. Section 5 was.
No, he may have cited it, but not in court before your lordships.
No, Mr. Sibal.
He may have cited it somewhere.
Section 5 and 6 were not read to us.
Never.
5 I read, Malad.
No, yesterday they were not read.
No.
Fortunately,
You may have cited it somewhere else.
Fortunately, we have.
Or somewhere.
I read it to your lordship that section 5 says for religious. I was telling your lordship under the Protected Monuments Act, it can be done only for.
No, you argued that section 4 and 5
takes away your right of religious observance.
1 second. I said it is now void. Earlier.
No, I will tell you what was your argument. Section 4 and 5, where an elaborate procedure is required for survey for declaring a protected area or protected monument, has been done away with by the 2025 amendment.
Correct. Now it is declared to be void. Previously, under the Act, under the Monuments Act, religious worship was protected.
So it was still protected. That's what we did not point out. Section says.
Now it is.
No, but subsection 6, which says that it shall not affect the customary religious observance, that was not what.
5D now says it is void.
Anyways,
the Wakf is void, not the ancient monument or the practice. But I do not know entire argument.
Anyway, proceed.
We'll answer that.
Lord, their entire argument.
We have only 15 minutes now, 17 minutes.
Lord, kindly
get disturbed, then you will not be in a position to.
Lord, kindly see why this was introduced. And the discussion with Lord, the JPC called the Archaeological Survey of India. It called the Ministry of Culture, and this is their representation. Lord, I'm posing a question to myself. Can this be said to be arbitrary in this any manner? Page 5. This is what was not read, my lord, at least in the court. Mr. Sibal has many forums where he reads many things, but not, my lord, in the court. Please see, this is a part of the JPC report.
1 minute.
And this is placed before Parliament before the bill is passed. Para 12, my lord, the quoted part, page 5 of the note, so that your lordship may not have to go through the JPC report. 4.6.14, my lord.
1 minute.
Lord, let me read this, my lord, Lord, a little carefully. As per archaeological.
1 minute. We are taking down the note so that there is no dispute.
But I have never disputed. Unfortunately, they, despite my affidavit, they argued everything against them. That this is not the correct interpretation. I said minimum 2. He said no, maximum it has to be maximum 12. As per Archaeological Survey of India, many state Waqf board has issued notifications in later dates declaring protected monuments as Waqf property, which have resulted in conflict in exercise of powers delegated under the Ancient Monuments and so-and-so Act. An indicative list of so-and-so. Please see 4.6.15. ASI have also submitted before the committee, that is JPC, that the Waqf board also restricts them from carrying out conservation or maintenance work in such protected monuments. There are various instances where Waqf authorities have carried out several additions and alterations in the original structure of protected monuments by themselves. 100 years old, property of national importance declared under the Act themselves, which adversely hampers the authenticity and integrity of the protected monuments, some of which are mentioned below. Dual authority at monument of national importance gives rise to conflicts and administrative issues. The representatives of Waqf or committee members involved in the monument sometimes take decisions unilaterally which are in conflict with the ASI policy. In some cases, even entry of ASI staff is restricted in certain parts of a monument on the pretext of privacy. Sometimes Waqf claim their ownership over the monument, which leads to management issues. The representative of Waqf or committee members or mutawalli associated with the monument sometimes allow photography, guiding, etc., sale of materials, etc., in protected monuments in contravention of the Act. In case of Dargah of Chistiya Maulin, Fatehpur Sikri, the Dargah committee has issued guide licenses. This has been objected by local guides holding licenses from competent authority. My Lord, your Lordships may skip C. D. In some monument, commercial activities are allowed by the representatives of Waqf or committee members involved. Further additions and alteration in the original structure of monument have been taken up to make shops so that they can be rented out for commercial activities. All these activities hamper routine conservation, maintenance of the monument. For example, Atala Masjid, Jaunpur, where the management committee does not let the ASI to perform any conservation work. New constructions have been done in eastern, northern and southern side of the mosque by the management committee. Shops have also been developed on either side of the main entrance. They did not allow ASI to fix any protection notice board at the monument. ASI had approached district administration for removal of encroachments. In Lal Masjid at Jaunpur, repairs and renovation work is being carried out by the management committee without informing the ASI. It is very difficult even to enter such monuments. Therefore, number and nature of the encroachment could not be ascertained. Sometimes other functions, activities, etc. are followed in the monument. Installation of fittings and fixtures, instruments and devices like loudspeakers, coolers, light fixtures, etc. in the masonry of the monument leads to the disintegration and weakening of the masonry and also mar the aesthetic value of the monument. All the above said activities are in violation of the Ancient Monument Act and also jeopardize the proper maintenance of the monuments in its original form. It is submitted that the Ministry of Culture has proposed Section 3D to be inserted, which is clear from the following. The query as to which are the amendments proposed in the bill that could address the specific issues or difficulties faced by the ASI, the Ministry of Culture submitted as under. Well, then the 3D came.
And when it was placed before the parliament, when the bill was placed before the parliament, 3D was very much there or?
Obvious, yes, my lord. My lord, what happens is the bill is placed before JPC. Bill did not have 3D. I must assist your lordships. Correct.
Draft bill placed before the JPC but might not be having 3D and
3D. Thereafter, 3D.
When the JPC's report came,
then 3D.
The bill which was placed before the parliament.
3D was placed along with the report also. That's mandate of the Constitution. And factually it was placed. It has to be placed and it was placed.
No, 3D as such was not a part of it when it went to the JPC. JPC considered this and along with the report, this 3D was also.
And the bill was amended, including 3D, and that included bill was placed before the parliament, which was passed.
It is not as if that 3D came subsequently by way of an amendment.
No. It is in the original amending act.
Yes.
It's part of the report, therefore. Part of the
Yes, my lord. This is a part of the report. Your Lordships may record page 245 to 247 of JPC report. This is what I have read. कौन बोल रहा है भाई ये?
You will have get an opportunity of rejoinder. We did not permit them to interrupt. We did not permit Mr. Tushar Mehta to interrupt you.
5 to 247 of my counter. There.
You address the court.
Pardon?
You address the court.
I'm sorry.
As an amendment for Parliament.
But Article 49, the directive principles, the state has the duty to protect monuments. And we have given reasons. But these reasons cannot be said to be either imaginary or something. They have given instances. And this can't, in my humble submission.
What about 3E?
3E, there are 3 or 4 sections I have to deal. Can I deal with it tomorrow, Malords? Because in any case, they will, need some time. Your Lords, it would spill over.
We have 7-8 minutes to utilize this.
3E, my lord, please see 3E. 3E, my lord, kindly see 3E. Lord, this is for protecting tribal land. What objection can one have? And no tribal is before your Lordships. Some people claiming to be leaders of all persons belonging to this community are challenging academically. And I'll cite Kusuming gods. There can't be an academic challenge to a statutory provision. 3E, my lord, kindly see. Bar of declaration of any land in scheduled or tribal area as Waqf, notwithstanding anything contained in this act or any other law for the time being in force, no land belonging to members of scheduled tribes under the provisions of the 5th schedule or the 6th schedule to the Constitution shall be declared or deemed to be Waqf property. Look, this is the classification in the Constitution itself. This Schedule 5 and Schedule 6 is a separate provision for tribal areas. There cannot be any Article 14 violation. It's a part of the Constitution itself. And please have a look, my lord, what the committee, my lord, the JPC says, page 571.
Yes.
Lord, this is, my learned friend wants me to show Article 244, for administration of scheduled areas and tribal areas. That's Constitution. Kindly, my lord, just make a note, Article 244. Because, my lord, my reply doesn't contain all this, my lord. Therefore, I'm showing, my lord, from this. But I would have given, my lord, facts, figures, everything, which I'll give, my lord, at the time of final hearing. I'm just pointing out prima facie whether this would be a case for staying this at the behest of nobody. Just an academic challenge. I don't like this provision. The provision of 5th schedule shall apply to the administration and control of scheduled areas and scheduled tribes in any state other than state of Assam, Meghalaya, Tripura and Mizoram. The provisions of the 6th schedule shall apply to the administration of tribal areas in state of Assam, Meghalaya, Tripura and Mizoram. That's all. It's a classification under the Constitution itself. And my lord, what the JPC says is this. It cites certain judgments. I'll just read. Your lordship need not open. It's in the, it has kindly note page 571, 572 of my reply.
You can give us the extracts.
I will give. I'll give. I'll just read and my lord provide the extract by tomorrow. I'll just read, my lord.
You can give the,
like this.
I annex it along with this.
Right, like this, my lord. Because there are 3, 4 provisions they have challenged, my lord. For example, your lordship, I was shocked. I don't know, but there was Limitation Act was not applicable to Waqfs. I'm repeating it. Limitation Act was not applicable to Waqfs. That is made applicable. I'm going to defend that also because that was also challenged. And I'll just read, my lord, on this, my lord. Recently, the JPC records, recently, numerous cases have come to the notice of the committee concerning declaration of Waqf lands in tribal areas falling under Clause 5 and Schedule, Schedule 5 and Schedule 6 of the Indian Constitution. Waqf in these areas is creating a serious threat to the existence of these cultural minorities whose religious practices are distinct and do not follow religious practices prescribed under Islam. Tribal Muslims have a different customary practices. The increase in the quantum of land acquired by the Waqf board and the number of litigations underscore the urgent need to address this serious concern. In this regard, the committee feels that scheduled tribes, being one of the most marginalized and vulnerable sections of the society, the protection envisaged by the founding fathers of the Indian Constitution should be upheld at all cost. Taking cognizance of the issue discussed above, the committee is of the view that the protection accorded to scheduled tribes and tribal lands under Schedule 5th and 6th of the Constitution must be upheld, and any threat, perceived or real, needs to be addressed. The committee therefore recommends that ministry should take appropriate legislative measure to forestall declaration of tribal lands as Waqf land in order to ensure protection of scheduled areas and tribal areas. This is the constitutional classification. And recommendation made by the JPC included in the bill which was placed before the parliament and the parliament passed. Lord, can I take 10 minutes tomorrow? Lord? There are only 3 sections, Lord, which were challenged, and I'll just, Lord, I'll prepare this kind of a note and place. Grateful. We will, my Lord, decide. Today we'll sit together and decide.
No, you tell us so that we can.
We'll factor it out accordingly.
I will not take more than 10 minutes.
We'll give you half an hour tomorrow.
Less than 10 minutes for me.
We'll give you half an hour. Just divide among yourself and what 45 minutes for your end.
We have a lot to answer.
Yeah.
For interim.
But everything was on record. You did not show it to the court. I have to show it. That's all.
That's why
you means sir. You means not
in the beginning, we had.
Regarding there can't be, no argument.
Very well.
That too for interim order.
Let's forget the past, my lord. We have a lot to answer.
That's correct. My lord, I am part in person. Please allow me.
No, thank you. We will give you, we'll give you half an hour and 1 hour to you, so you just divide the time of that.
That's correct. Please, Your Lord.
1 hour to them. Yes, yes, whatever. Your lordship can, my lord, it's absolute discretion.
That's good enough for you. Half an hour you'll be able to.
Yes, yes, I'm not, I'm just asking.
Please.
Grateful to.